Good morning, honorable members. And good morning to the guests, all welcome.
Recording in progress.
Later, I will be having a quorum for the meeting.
Good morning, Chair. Good morning, honorable members and everyone present in the platform. Chair, there are only 3 members of the committee so far. Can I quickly try and get hold of the other members just to check where they are?
Okay, so that's all then.
Recording stopped. Recording in progress.
Greetings again, Chair. I see now we do form a quorum. Thank you.
Thanks a lot. Let me welcome everybody on the platform and just taking you a little bit back where we started. We are continuing with the meeting that was left yesterday because of time constraint. It was late. We took a very long time. But the idea is to ensure that everybody get enough time to participate in this meeting. And that, yeah, that's why we took so long yesterday and couldn't even finish what we're doing. But I just want to go a little bit back to remind members and those on the platform where we started. The Basic Education Laws Amendment Bill is, well, popularly known as the Bella Bill. Its B2B of 2022 was reverted to the NCOP since the 23rd of October last year, and was subsequently introduced to the Select Committee on Education and Technology, Sports, Arts and Culture on the 8th of November. The committee, together with the provincial legislatures, conducted the public participation processes on the bill and have since received the negotiating mandates of all provinces. After that, the Department of Basic Education had to respond to all the issues raised during the public participation process of the committee and the provinces. During any lawmaking process, honorable member, the Parliamentary Legal Services Department conducts its own analysis and interpretation of the bill in contention and advises the parliamentary committees on any legal matters pertaining to this bill. This is to ensure that the process of passing any bill is both procedurally and legally sound. We all remember that during the public hearings, people who gave inputs during the oral presentations, we were promised that if we pass this bill, we'll be taken to court. So as a result, we're dealing with this bill in that manner that we don't want to miss anything or compromise any step or make other people feel that they are not given enough time to participate. So as we engage, we are aware that there will be this legal challenges in the courts at a later stage. So therefore, with the brief background, the purpose of today's meeting is to receive briefing by the Parliamentary Legal Services on the major clause-by-clause issues raised during the public participation processes. And as part of the negotiating mandates of program, the legal services will also be addressing any procedural issues relating to the flow of this important bill. This meeting is important, members, because it will provide a legal perspective that aims to assist members in being informed and to deliberate on any concerns prior to the finalization of the mandate. With these few words, I welcome all the stakeholders to this important meeting, and I look forward to the engagement that members will be raising with respect to this briefing. Yesterday, I think we stopped, where were we at the clause 15. Let me just we stopped at clause 15, and clause 15 was clause 15 seeks to amend section 22 of the SASSA to empower the HOD to withdraw on reasonable grounds and after complying with prescribed requirements, one or more functions of an SGB. This is about SGBs that have stopped to exist. Even in such cases, the head of department is obliged to follow prescribed procedures. So this is where we are at. We voted on this one, Noltando, if you could just remind me.
Yes, Chair, the committee did vote on clause 15.
All right. So now we are moving to clause 16. And I'm hoping that we'll finish this today. I'll need to advise on how to continue, because I foresee yesterday it took us, we did half the work, and I was taking that in instances where there is agreement amongst members, we should not engage that much. So if there are no amendments, we'll just pass that part. Is it we'll just pass that clause and say there is an agreement on this clause. So we'll just let the legal person, the presenter, to present that part, the clause, and then without even having to engage, we'll ask if there's anyone who, and then if there is agreement, then we'll move to the next clause. Will that be okay, legal and members?
Good morning, Chair.
Honorable Njadu.
Thank you very much, Chair. Good morning to all the members. That sounds very great, Chair. Thank you very much. Agreed.
All right, thanks. I guess we should move to clause 16, which seeks to amend section 23 of the SASSA to empower the governing body to co-opt persons from outside the community with the relevant expertise to assist in discharging its functions. I think that is what it's all about. Let's give over to Ms. Ngema and the legal team to lead us in this on this clause. Over to you, ma'am.
Good morning, Chairperson and the members on the platform and everyone that has joined and participating with us. Thank you once again for this opportunity, Chairperson. May I request sharing rights, but so long I will continue, Chairperson. I was just gonna light the B bill on the provisions that we are on. Today we are starting on clause 16, and as Chairperson has already indicated, 16 is seeking to amend section 23 of the SASSA Act, and it is on membership of governing body or of ordinary public school. So in this instance, the only insertion or addition that is done is to bring in subsection 6 and amend it so that governing bodies are enabled wherever necessary to discretionary co-opt members from a community that is outside of the nearby community school where the school is located. So that is basically what is being done by that provision, so that the relevant expertise that they may not have within their own cohort can be extended to those who can assist them. So Chairperson, that is clause 16. And I don't think there were much submissions that we're contesting on this one. Thank you, Chair.
Thank you. I'll give over to members. Anyone wants to comment on this?
My hand, Chair.
Honorable Munyai Shilizi. Gauteng.
I will believe that this bill is fine as it is, and the recommendation, Honorable Chair, that the clause must remain as is, because our view that it recommended that there needs to be an investigation into the need for expanding the authority. 2, I must put this in inverted commas, 1 or more function instead of single functions. But I know you were speaking to the issues of the of clause 15, so that's what I contributed to. But with regard to SGB, if we are going to clause number 16, I must say that there's a need to define the term of community, and the clause is fine as it is, as I said. The inclusion of the proposed amendment as per WCED submission, the definition of community to be inserted. Alternatively, the term to be deleted, whether the provision to be drafted by the department applying to any persons with the relevant expertise. I commented already on 15, but I also dealt with my position on 16, Chair.
Thank you. If you could lower your hand if you are done, Honorable Munyai. Thank you very much. I see the hand of Honorable Christians.
Thank you very much, Chairperson. Chairperson, I would just like to refer to the Western Cape Education Department proposed amendment, and I would like to agree with it that the definition of community be inserted, or alternatively the term be deleted. Provisions to be drafted to apply to any person with the relevant expertise. Thanks, Chairperson.
Thank you, Honorable Christians. Is there any comment from the members? The feeling is okay, then we'll have to, I think we'll take this one to a vote without having to engage deeper like that, because you have said that we see the recommendations of the Western Cape, and Honorable Monyai has said that there's no need to define the term community, and that the clause is fine as it is.
Chairperson.
Honorable Ngozi.
No, thank you very much, Honorable Chair. Greetings to your good self, all members present in the platform. No, Chair, I would like to support Honorable Munyai that there's no need for the term to be defined. Community, the clause is fine as is. Thank you.
That being the case, I put the vote. Those who say there's no need to define the term, it's okay as is, and there are those who say we need to define what the community is. I'm going to call the delegates per province for a vote. They will start with KwaZulu-Natal.
Good morning to you, Chair, and good morning to the colleagues and honorable members. I'm not sure if our permanent delegate is present in the event. She's not in the meeting. KZN support the clause as it is.
Thank you. Eastern Cape.
Chairperson. Good morning, Chair. The Eastern Cape support. Chairperson,
yes.
Honorable Muto from Cape. I was struggling with the unmute.
Who is favor. That?
It's Honorable Mutua from KZN.
Oh yeah, no, thanks.
Yes, I was struggling to unmute, so I'm in favor. Thanks.
Yeah, it's the province that is voting. Yeah, it's okay.
Yes, Chair. I sorry, Chair. I was it's Sonjika. If our permanent delegate is here, she's correct to vote, and so I'm okay with it.
All right, thanks.
Thank you.
Okay. Limpopo.
Thanks, Chairperson, and good morning to all the honorable members. Limpopo support. Thanks.
Limpopo support. Yeah, the Free State. The Free State province. Northern Cape. Northern Cape.
Chairperson, in the absence of a clause-by-clause draft that I've requested from the Northern Cape yesterday, which they have not sent, I am unsure on how to do this clause 16. I've also requested Nolutando to request the province to send me a clause-by-clause draft, such as the Western Cape had done. So it's very difficult in circumstances where we decide on an amendment within the meeting how to vote for the province, Chairperson, if you understand my difficulty.
But yesterday,
I've also,
everybody got information. We all got the same document. Naltando confirmed that they sent the documents to everybody. All of us got the same documents. So I
yes,
don't understand. I don't understand what your problem is.
It's not clause by clause, Chairperson. All they've done was they've drafted the submissions of the stakeholders and they've drafted the submissions of the individual people. But the committee themselves, Chairperson, have not specified clause by clause, description by description, neither have they given a provincial mandate per clause. But in the absence of that, Chairperson, I suppose then in that case, the Northern Cape would support it. But it's very difficult in this case, Chairperson, because as I say, the Northern Cape has not done due diligence in this and done the descriptions and their provincial mandates clause by clause. They've simply sent in a document where they've described the stakeholder inputs. But having said that, Chairperson, if they haven't done that in that case, I suppose, and we haven't heard back from them either, because I've asked Nolitando to request that from them yesterday. In that case, I suppose then they would support it if they haven't done it clause by clause.
Can we move to the Western Cape?
Thank you, Chair. Good morning to all the members. Chairperson, the Western Cape, according to its position, for the proposed amendments, believe that the Western Cape is not supporting.
Can we get to the Northwest? Thank you. Northwest.
No. Chairperson, Northwest is in favor.
All right, thank you. Mpumalanga.
Thank you very much, Honorable Chair. Mpumalanga support that clause to remain as is. Thank you.
Gauteng, thank you.
Good morning, Chair, and all the members in the meeting. Gauteng supports.
Thank you, Honorable.
Chair, did you call Free State?
There was no answer from the Free State.
Oh, my
Free State.
apologies, Chair. I didn't hear. We vote in favor, Chair.
Thank you.
Chair, what about Eastern Cape?
Did we leave another? Did we leave another province? Eastern Cape.
Eastern Cape agrees, Chair.
Thank you. Let's move to clause 17. Clause 17, as we know, seeks to amend section 24 of the SASSA to empower the minister to determine in a national gazette.
P.
No, can you just mute your phones, please? Clause 17 seeks to amend section 24 of the SASSA to empower the minister to determine in a national gazette the number of SGB members, manner of election or appointment in public schools for learners with special educational needs. Clause 17, Mayor Ngema, legal team.
Thank you, Chairperson. Clause 17 is the one that seeks to amend section 24, which is on membership of governing body of public schools for learners with special education needs. So here, Chairperson, what the provision seeks to do is to alter the power that was conferred on the MEC to determine the number of members in each category referred to in subsection 1 of the 24 of section 24(1), so that it changes that power will now be done by the minister, and after considering the submissions that would have come in. Subsection 1 does set out the categories that would have to be considered. And just to mention a few, it speaks to the category of parents of learners at the school. It speaks to the category of educators. It speaks to the category of learners attending the 8th grade or higher grade. It speaks to the representatives of sponsoring bodies, representatives of organizations of parents of learners with special education needs. It speaks to representatives of organizations of disabled persons. It speaks to disabled persons themselves, as well as experts and principal in their official capacity of these schools. Chairperson, I think one of the submissions that spoke to this is to say, once again, if the power is given altered from the MEC to the minister, there is an issue with that because it's another form of centralization. But I think the department also responded in this submission to indicate that there is nothing that the minister does without consulting the MECs when things like this and matters that are to be gazetted are done. So already there is a form of inclusion and involvement and consultation with the MEC. Thank you, Chairperson. That would be clause 17.
Hello, Chair. Chairperson. Chairperson.
Oh, I was muted. Yes. Honorable Njadu, the floor is yours.
Thank you, Chairperson. Can we just correct the screen because it's showing clause 18.
All right. That will be corrected. Clause 17.
Is the screen showing the bill, Chairperson, on 17?
I'm trying to.
Not sure myself.
It does.
Thank you.
It does. It's 17 at the top, and it's the amendment of section 23 of Act 84 of 1996. That is the SASA Act. Yeah, it is. I'll wait for hands. You have already made the presentation, gave your input on this Mengema,
Indeed, Chairperson, I just did now that it's just a matter of.
Thanks a lot. I can only wait for hands. I can't call people to talk if they don't raise their hands. Honorable Christians.
Oh.
Honorable Christians, the hand is up.
Thank you, Chairperson. Chairperson, I would just like to state that I oppose the amendment proposed in clause 17. It consolidates power excessively by transferring authority from the MEC. This is a risk in centralizing the decision-making. This shift could encroach upon the provincial autonomy, potentially interfering unjustifiably in provincial matters. I therefore advocate, Chairperson, that we as the committee delete clause 17 to maintain the power of balance and to uphold the integrity of provincial governance. Thank you, Chairperson.
Thank you, Honorable Christians. Honorable Ngozi.
Thank you very much, Chair, and thank you to Mangema for presenting this clause. Chair, with the explanation given to us by Mangema, that speaks of the uniformity regarding the clause and further indicates that the minister does not work alone, but with MEC through the Council of Education Minister in gazetting anything. I feel that, Chair, let's leave the clause as is and support it. Thank you.
Honorable Munyai.
Thank you, Honorable esteemed Chair and honorable members, and all the people of South Africa and all that are before this House. Honorable Chair, South African government and the spirit of the Constitution is not advancing federalism. It's a unitary government. So even the powers of the ministers, they derive them from the cabinet. But the proposition that I'm bringing forward clearly as it is, because there's no such a thing called autonomy of the provinces in the Republic. We have a unitary government. So I'm opposed to that view that has been put forward. So this is uniformity. The minister does not work alone, but work with the honorable MECs through the Council of Education ministers in gazetting anything. So any suggestion that seeks to advance autonomy will seek to advance federalism against a unitary state, and that should not be allowed in the Republic. Thank you.
Thanks, Honorable Munyai. Is there any member want to say further comments on this? None. Therefore, I put the vote on clause 18. How are we voting on clause 18?
It's clause 17, Chair.
Look.
Sorry.
Oh, look, I've moved to page 18. So clause 17, yeah. One is that the minister will be given more powers, and the other one says that no, we're leaving it as it is for uniformity. So how are we voting on this one? Leaving it like this as it is, or having it removed?
Hello, Chair.
Yeah, Honorable Njadu.
The Standing Committee of the Western Cape opposes.
Now we're going to come to the voting later after this. So I'm going to put the vote. I'm going to put the vote. Oh yeah, no, okay, you can say the Western Cape. Yeah, it's opposed, you said.
Yes, Chair.
All right, thanks. The Eastern Cape.
Eastern Cape agrees, Chair, that the minister does not work alone, but with MECs through the Council of Education.
Thank you.
Thanks,
KwaZulu-Natal. Limpopo.
Limpopo support the clause as it is without any changes, Chairperson.
Thank you. KwaZulu-Natal.
Chair.
Honorable Sonji.
Yeah, yes, I suspect that Honorable Muta is backing. KwaZulu-Natal supports that the clause remains as it is.
Yeah, I see. I don't see her. I think she's struggling with the connection. Limpopo is done. The Free State.
Free State agrees, Chair.
Thank you. Northern Cape.
Northern Cape supports, Chair.
Western Cape, not. Northwest.
Northwest support, Chair.
Thank you. Mpumalanga.
Mpumalanga agrees, Honorable Chair.
Gauteng, thank you.
Gauteng supports, Chair.
Well, thank you. Clause 18 seeks to insert section 24A to regulate membership of governing body of a public school with a specialized focus on talent. This is currently unregulated. Let's hear from the members, raise of hands. It seemed like this clause was supported by all the members. Do we have to go through it, Bengema?
Chairperson, you can just put it to the members for voting and they confirm that they all support.
All right. Yeah, this one is supported by everybody. Let me put it to the members who, just to confirm, Eastern Cape.
Eastern Cape agree, Chair.
KwaZulu-Natal. Limpopo.
Limpopo support, Chairperson.
Free State.
Free State is in favor, Chair. Thanks.
KwaZulu-Natal, thank you. KwaZulu-Natal.
KZN support.
Thank you. Northern Cape.
Northern Cape supports, Chair.
Western Cape.
Western Cape opposes, Chair.
Northwest.
Northwest supports.
Mpumalanga.
Mpumalanga supports, Chair.
Gauteng.
Gauteng in favor, Chairperson.
Thank you. Honorable Jadu, I'm seeing from my papers that on the Monday, as I'm checking, the Western Cape has also supported this, I guess. But now that you say they did not support it, but it's okay.
No, Chair,
I'm just saying.
can I just check, Chair, because I'm taking it as I receive it. Can I put it as received?
Okay, sure.
The standing committee opposes this clause. That's
Okay,
17.
sure. No, then if they're opposing it, yeah, no, it's okay. Because on my papers, I thought they were agreeing with the input. Is there any province that I have left out? No. You may continue, Honorable Njadi, to read the objection of the Western Cape. Sorry, I nearly stopped you from doing that.
Okay, thank you, Chair. The objection of the Western Cape is the transfer of this power from the MEC to the minister amounts to a greater centralization power, and it's thus opposed. This could constitute an unjustified intrusion into the provincial sphere.
Yeah, you voting on a wrong clause. We're at clause 18. No,
that's 17.
18. That was 17. We have already voted on 17. We are now
Okay.
at clause 18. Yeah.
Oh, all right. No, Chair. No, my apology,
yeah,
Chair. Apology.
Yeah.
18
So
is
what is this?
18
What is the position of? Just wait a bit. Let me finish my sentence. What is the position of the Western Cape on clause 18?
The Western Cape support 18, Chair. So Western Cape support 18. My apology.
Yeah. Is there any province that I have left out? Noltando, you may give us the results of the voting on 17 and 18.
On clause 17, Chair, 8 out of 9 provinces are in support, and on clause 18, all provinces are in support.
Thank you very much. We're moving now to clause 19.
Clause 19, Chairperson, it is seeking to amend by the substitution section 25, and section 25 is on failure by governing body to perform functions. So what clause 19 proposes, as I said, is substitution of section 25 in order to empower the HOD to dissolve an SGB that has ceased to perform the functions allocated to them in terms of the Act, and if the HOD has reasonable grounds to do so. Then provision is made for the steps on how the HOD may take that process forward by including the appointment of sufficient qualified persons to perform the functions of the SGB for a specified period. The clause also deals with the voting rights of such persons and provides that the HOD may act in terms of this section only after following certain prescribed procedures as set out. The clause also provides that the HOD must ensure that a new SGB is elected within a space of 1 year and provides for an appeal process, Chairperson. So that is the provision that I've lighted up on clause 9 on clause 19 in summary, Chairperson, to deal with the dissolution of the SGB when they become dysfunctional.
Thank you very much. Any comment? Oh, Honorable Munyai. Thank you very much.
Thank you very much. The clause is supported and no changes is recommended in this regard. Thank you, Chair.
Thanks. Honorable Christians.
Chairperson, I would like to recommend, at the moment it says there's a 14-day appeal procedure. I think that's a little bit unrealistic, and I would like the committee to recommend a slightly longer appeal timeline, perhaps to 30 days. That would seem more reasonable, Chairperson. Thank you.
Thank you very much. Any other comment? Now I'm going to put the vote. Those who say that the 14 days procedure is unrealistic and should be extended to 30 days. And there are those who say no change is recommended on this one. I'll call the provinces now to vote. Eastern Cape.
Eastern Cape, no changes is recommended, Chair.
Thank you. KwaZulu-Natal.
Chair, KwaZulu-Natal support the no changes.
Thank you. Limpopo.
Limpopo support with no changes, Chairperson.
Thank you. Free State.
Free State supports with no amendments, Chair.
Northern Cape.
Supports with no changes, Chairperson.
Western Cape.
Western Cape recommend the extended to 30 days, meaning it do not support.
Northwest, thank you.
Northwest supports without no changes.
Thank you. Mpumalanga.
Mpumalanga supports with no changes, Chair.
Gauteng, thank you. Gauteng.
Gauteng supports, Chair.
Thank you. Noltando results.
On clause 19, 8 out of 9 provinces are in support, Chair.
Thank you. Clause 20. Recusal of members. Angema.
Thank you, Chairperson. We are on clause 20. And clause 20, as you have already pointed, is amending section 26, and its title on the Principal Act, it's recusal by members of governing body. What it does, Chairperson, it proposes to change section 26 where a provision for the declaration of a direct financial interest is done when the SGB's close members, or when they are deciding matters where they have an interest on. So it's basically an issue that deals with the interest by the SGB and what process is to be done thereof, Chairperson. Thank you.
Thank you very much. Honorable Munyai, your hand is up.
Thank you, Honorable Chair. I will say that first and foremost that an additional provision to be added to the proposed amendment to provide monitoring of compliance with this provision by district. Further, the committee recommends amendment of clause 20, amending section 26, subsection 1 of the SASSA, removes the words, I'm quoting the word that we need to remove, personal and financial. Those words need to be removed. Amend to clause 20, amending section 26 and subsection 3 of the SASSA Act to remove the word personal, and amend the clause 20, amending section 26, subsection 4 of SASSA to remove the word personal. With regard to my input now for your consideration, all clauses have monitoring implications. Amendment to join personal and financial reason supported.
Thank you, Honorable Munyai. Any other hand?
Let me just check. I said amendment to join personal and financial reason cannot be supported. Must have passion to drive this way. GP as well.
I missed that part, Honorable. Can you come again?
Move the issues of let me just go back on clause 20 there. Remember I said we must remove the words personal and financial, you know? And as I said it, I can repeat my contribution that an additional provision to be added to the proposed amendment to provide monitoring of compliance with the provision by district. Further, the committee recommends, or we recommend, or I recommend amendment of the clause 20, amending section 26, subsection 1 of the SASSA to remove the words personal and financial. So amendment to the clause 20 in this regard, we are removing the word personal, and amendment of clause 20, as I said, as guide with respect to section 26, subsection 4 of the SASSA, we remove personal. So in this regard, all clauses have monitoring implication, Chair.
Chairperson, may I read 26.1 and 26.4 so that members can follow on what is being said?
Yeah, I'm getting. I was actually going to ask that. Yeah, to refresh our minds on this one.
Section 26.1 that is going to be effected and as proposed, it says, before a governing body discusses or decides on the recruitment or employment of staff or the procurement of goods and services for a public school, that member of the SGB must declare to the governing body any direct or indirect personal and financial interest that the member or any of his or her family members or close friends or business partners has, including a personal interest in any entity conducting the business with the school, in a business or a commercial or financial activity undertaken by the governing body of a school. And sub 4 as well, Chairperson, it says if a governing body has knowledge that a member who is present has a personal interest in a matter, the governing body may not take a decision on that matter until the member has withdrawn as contemplated in subsection 3. So the removal of the suggested words, Chairperson, will make the provision meaningless.
Yeah.
Because it clarifies the kind of interest that needs to be addressed by these provisions.
Now better, Chair, through you. Better clarified now. All clauses have monitoring implication. The amendment to join personal and financial reason is supported. Thank you.
Thank you very much, Honorable Munyai. Honorable Nkosi.
No, Chair, thank you very much. With that said, by Mungema and Umunyai, Honorable Munyai, I would like to support him for the amendment to join personal and financial reasons be supported, Chair. Thank you.
After clarity by Mangema and the input of Honorable Munyai. Okay, thank you. Is there any other comment that members would like to? So, and then those who agree that amendments to join personal and financial reasons supported should raise their hands. So I'm going to ask the Eastern Cape.
Eastern Cape agrees, Chair.
KwaZulu-Natal.
My apologies, Chair. KwaZulu-Natal support.
Limpopo.
Limpopo support the clause without any amendments, Chairperson.
No, okay. There are amendments here. So it means you're actually not voting with that because we're saying.
Chairperson, sorry, Chairperson. They were talking about the recusal issue. So
Oh,
I think
okay.
the recusal issue,
All right.
the normal practice everywhere, Chairperson.
All right, thank you. That was Limpopo. Free State.
Free State is in favor, Chair.
Northern Cape.
Northern Cape supports without any amendments, Chairperson.
Western Cape.
Chair, just to make sure, 20 is the standing, the standing committee supports with the following amend. As per the Western Cape submission, the committee recommends that an additional provision to be added to the proposed amend to provide monitoring of compliance with this provision by districts. Further, the committee recommends amend to clause 20, amending section 26(1) of the SASSA, removes the words personal and financial. Amend to clause 20, amending section 26(3) of SASSA to remove the word personal, to remove the word personal, and amend to clause 20, amending section 26(4) of SASSA to remove the word personal. That is the position of the Western Cape, Chair.
Thank you, Honorable Njadu. Northwest. Northwest. Mpumalanga.
Thank you very much, Honorable Chair. Mpumalanga agrees.
Gauteng.
Gauteng agrees, Chair.
Thank you. May we move the result to Nomtando.
On clause 20, Chair, I'm not sure whether to say the Western Cape supports or but 7 out of 9 provinces are in support, Chair.
Okay, thank you. The supported. So it will be what, 9 out of 9?
It's 7 out of 9, Chair, because the Northwest didn't vote.
Who's the Northwest delegate?
In favor, Chair.
Northwest?
Northwest support.
All right, let's move to
Clause 21, Chair.
clause 21. I'm going to ask members, please, to be attentive in the meeting. So what makes us to take more time on this is because members are not being attentive. Let's be attentive, all members. We're on section 21, the enumeration of SGBs.
Thank you, Chairperson. Clause 21 indeed is amending section 27, which deals with the reimbursement of members of governing body. The clause is seeking to clarify, and as already it exists, that members of the SGB are not entitled to be remunerated for the performance of their duties. However, or for the attendance of meetings at the school or the school activities. So it is clarity to ensure that this does not take place. Yes, Chairperson. There is no reimbursement, and I think the submissions were indicating that perhaps we should consider speaking to just providing what may be necessary for some of the members to get to the places when they are unable. So that is clause 21, Chairperson, on a general prohibition that SGB members cannot be remunerated or paid for the duties that they do in respect of being an SGB member. Thank you, Chair.
All right, thank you very much. Honorable Manyai Chilizi, Gauteng.
Thank you, Honorable Chair. The clause is wholly supported and no changes is recommended.
Thank you. Is there any other comment on this one? In the absence of any, I put the vote. Those who support Eastern Cape.
Eastern Cape supports, Chair.
KwaZulu-Natal. KwaZulu-Natal. Limpopo.
Limpopo support, Chairperson.
Free State, thank you.
Free State supports, Chair.
Northern Cape, thank you.
Northern Cape supports, Chair.
Thank you. Western Cape.
Western Cape support, Chair.
Thank you. Northwest.
Northwest support, Chair.
Thank you. Mpumalanga. Gauteng.
Gauteng supports, Chair.
Mpumalanga. Mpumalanga. All right. Mpumalanga is not present. May we get the results, Noltando?
On clause 21, with Mpumalanga outstanding chair, 8 out of 9 provinces are in support.
Thank you very much. Let's move to clause 22.
Chairperson, just before.
Honorable Baha.
Chair, I'm a bit worried or a bit disturbed that I never received a clause-by-clause input to this meeting. And it's Honorable Munyai who's able to do that. And I think I carry the Gauteng mandate. And therefore, anything that is supposed to be raised in this meeting I should have it as well. And now, for me, I'm like a voting cow that I must just vote, and he makes the inputs, and inputs that I don't have as a Gauteng delegate. So I'm just raising it, Chair, as a concern, because it's like yours is to vote, and you must vote in favor, and mine is to make inputs in terms of proposed amendments or anything of that sort. And for me, that says that why should I be in this meeting if I'm not in possession of what should be the inputs from the province to this particular meeting? So I'm just raising that, Chairperson, as something that is not sitting well with me, because I think that I should just keep quiet for that matter. And he continues to make inputs and vote as well. Then I just be part of the meeting and be quiet as a Gauteng delegate, though. Thank you, Chair. I just thought that let me register that in this meeting, and as something that is not really sitting well with me. Thank you, Chair, for allowing me.
Honorable Bach and honorable members, we discussed this matter was raised yesterday by Honorable
Chair, I raised my hand before, please, you summarize.
Christians.
Chairperson, I raised my hand before you summarize, please, if I may be allowed.
All right, you may.
I sent clause by clause through Jocelyn, who is supporting the honorable member. And also this morning, realizing that Jocelyn has not forwarded it to the honorable member, I decided even to send the copy to Jocelyn and copy again the secretary of the portfolio committee to send to the respectful honorable member. I've done my job. Jocelyn has not done her job. I don't know why she must continue to be there if she doesn't support the honorable member. Thank you.
I think I don't think this belongs here, even though members can complain about if they did not get documents, and we will make. Yesterday actually said that Noltando should check if documents were sent to people, and she checked and resent the documents to everybody. And I really don't know what is this. Noltando, can we hear from you, so that I don't want to close this matter before we hearing what you have to say. It seems like we have disadvantaged Honorable Baha and Honorable Christians, Northern Cape and Gauteng. May I also, just before Noltando could respond and repeat what she said yesterday, may we hear Ngema, the legal team, our lawyer?
Thank you so much, Chairperson. I think, as you have correctly indicated, some of the matters really are not to stifle this meeting. The participation, as the chairperson explained when the meeting started, the participants from provincial legislatures, it is a deliberation process. So it is a deliberation process on the bill. They are allowed and enabled to speak and make their views. It is when we speak to the mandate and the voting stage that, because as a deliberation, it means the members are engaging one another to find one another on the issues that have been raised and also assist one another understand their positions and their views. So the discussion is a discussion that must take place with any member making a view that they have. Others could be guided by what is in the mandate, others could be guided by what they understand the provision to be meaning. So participation and discussion is broad and open, Chairperson, as long as it is a member that has a right to speak and deliberate on the issues as the matter is before the NCOP. The difference is only on voting, Chairperson. So I am actually not clear myself. As you have pointed out, the issue should be addressed elsewhere and be sorted by the members and the provincial legislature that is engaged or facing the problem that is maybe coming out in this meeting. And the documents that have been shared from the Office of the Secretary of the Committee, Chairperson, you have already also pointed out that those documents, when the committee secretary sends out, I can even vouch that it is attached and sent to all the members of the committee, which means the documents may be lingering somewhere in the emails of the members, and therefore it's a responsibility of each member to ensure that documents within their position, if they are not able to access the electronic methods, it must be indicated so that other means to ensure that they have documents are done. Otherwise, then there could be one arguing that the issue is tainted because members does not or did not see the documents that have been sent. But the official documents, like the mandates, each member is supposed to be having them because they are arising out of their own processes of their own provincial legislatures, Chairperson. Thank you.
I just want to say, okay, let's hear Honorable Christians, followed by Honorable Baha.
Thank you, Chairperson. Chairperson, I would like to categorically state that I have not received a clause-by-clause mandate or discussion or document from the Northern Cape. They've sent their negotiating mandate. I read my emails as they come. I do due diligence when I receive emails from the province. I have stated on numerous occasions that I have not received such a document from the Northern Cape, and I want to reiterate, it makes it extremely difficult to vote on these matters. And additionally, Chairperson, I also want to mention that I'm afraid that we are not, as a committee, discussing these clauses, clause by clause. When, for example, one of us make a proposed amendment, it is simply taken back to provinces to decide on that amendment. And that should not be like that, Chairperson. We should, as a committee, be discussing each proposed amendment as it comes. So that is my input, Chairperson. I 100% did not receive a clause-by-clause document discussion mandate from the Northern Cape. Thank you.
Okay, sorry, Chair.
Yeah, Honorable Baha, yeah.
Chairperson, I want to take exception to what Mangema is raising, because it has an assumption that one does not check his emails. So this must have been sent and I might not have seen it. I take exception to that. There was no document sent to me, Chairperson. So any thought that I might have missed it is incorrect. I did not receive anything. I can sense that Honorable Munya is reading from the mandate from Gauteng and documents attached to it, which I do not have. I did not receive anything. Now, mine is just to sit here and vote as a Gauteng delegate. And I'm really, really not happy about it. That's all that I'm trying to say. I don't have anything. I did not receive anything. Nothing was sent to me. But I can't just sit in this meeting and be a voting cow, having not been given all the documents that are required for this particular meeting. That's all that I'm saying, Chairperson.
Colonel Baha, you did not, okay, yeah. You did not receive any document from the, okay. I see the hand of Honorable Sonjika. You'll be followed by Honorable Manyai. And then after that, I'll give the committee secretary to respond to this so we can move. And there's also the head of Honorable Ngosi. You'll be the last on this one.
Thank you very much, Honorable Chair.
Honorable Baha, may we lower your hand if you after you're done talking.
I'm sorry, Chair.
Thank you very much, Honorable Chair. I don't know whether it will help the meeting because I'm also not a committee member, but I just wanted to indicate how in KZN we dealt with clause by clause issues. Where we had no issue, we actually also did not comment. Where in terms of the public participation and the committee deliberations, we in sending our mandate to the NSOP, you will have seen, Chair, we made inputs where we for example, yesterday I indicated that we think the department has responded to issues or concerns that were raised by the committee. So you will find that in some of the clauses or most of the clauses, we're not as KZN, we have not really said anything because we felt that the clauses were okay. I don't know if it would help the meeting to make assumptions that when a province has not said anything, it's because they are not they don't feel like there is something to add or subtract in the clause as written in the B. I don't know if it will assist you, Chair, and the meeting.
Thank you. It makes a lot. Honorable Ngosi.
No, thank you very much, Honorable Chair. Let me start by apologizing, Chair. On clause 21, I couldn't vote for the province. Actually, I was cut out by the network. So when I come back, you have already passed that one. But the province is voting in favor. Chair, I think Honorable Sonjita has covered me, but I just want to comment as well. As to say that we have started this process yesterday, and there were no problem. There was no problem regarding the voting and all that. I think we must continue, Chair. And I think what is said by Honorable Sonjita, it's quite correct. According to me, is that the clauses that are brought here, I think the Secretariat has consolidated. That is why they brought them here. And my understanding as well is that if there's nothing from your province, that is why maybe there's nothing given to the comrades, to the honorable members. I want to say that because understanding is that there's nothing from their provinces. What is read by Honorable Munyai, I think it's what he's thinking of, what is thinking of out of his mind regarding these clauses, because we all know what is happening or what is contained in the bill. Thank you. Thanks so much. Thank you.
Honorable Munyai.
Thank you very much, Honorable Chair. I don't want to derail this meeting with Gauteng and Gauteng delegate. I will appreciate that, Honorable Bacher, if you can just text your number and your email on the chat. I will send you directly, because I see the report from Jocelyn here said that I can't send Honorable Bacher, and the reason therefore I'll forward it to you personally. Just text your number on the WhatsApp, and I'll send you direct, and your email I'll send you directly. I really apologize that as Gauteng were derailing the session of the clause by clause. Please just text it on the chat, then I'll send you directly, Honorable Member. I profusely apologize that what I sent, the necessary stuff as a Gauteng matter, did not reach you out. Thank you.
Mangema.
Thank you so much once again, Chairperson. I think quickly, Chairperson, let me try and explain the process. First of all, the members would recall that the previous meeting did speak to the negotiating mandates. And the meeting today, even on the Z list, the notice that notifies everyone about what is to take place in Parliament, it is indicating that it is deliberations on the clause by clause of the bill. What does deliberation mean? A quick check, Chairperson. Deliberation means a long and careful consideration or discussion. And from what has taken place with the mandates that the members have from their own provincial legislatures that they are delegated to represent. And as a member of this committee, you have two responsibilities. As a member, you speak to the issues that you want to speak to, that you would do at any other given time when a matter is programmed to be on the activities of this committee. At the same time, and fortunately, I think, which is a system that is also good in a way, there are permanent delegates and there are also alternative delegates. And also the extension that when a meeting of the select committee is taking place, a provincial legislature member is able to make a discussion and make views on the matter. So this is exactly what I said, Chairperson, earlier on. And if there are any statements that may have landed incorrectly with some insinuations, that was not the intention. What I was basically indicating that as a member enabled to speak in this committee, there are different angles and parameters that you could be speaking on and the information that you are speaking on. And as I said, members are also having their own minds, and what we do and what support that is there within the system, whether at the provincial legislature or at the parliament itself, is merely a support system. And I think just to add another layer, Chairperson, members could also engage their liaison officers that are situated and employed by Parliament to be the in-between people between Parliament, the committees, as well as the provincial legislatures. As I understand, there are liaison officers that are appointed and designated for each and every province so that this break in line does not happen. And when an information or documents are sent, these people are also included when we are dealing with the work of the National Council of Provinces. I thought I should just clarify that because it may be glitches that are in the system and communication, but the system is making all attempts to ensure that such things are addressed and do not happen. Thank you, Chair.
Thank you very much. You may lower your hand. Is there anyone who wants to talk on this? Noltando, I'm coming back to you again. You were asked to give. Did you send document to everybody in this? I just want to say that so that we can move. If we have forgotten to send papers to the two members, then we'll actually see what we do going forward. But otherwise, for now, in as far as I know, papers were sent to everybody, unless you tell me something otherwise. Ms. Kak Noltando, Committee Secretary.
Greetings again, Chair. Greetings, honorable members. Chair, I do forward each and every document that I receive from the provinces to the members. So all the documents that I've received so far, I have forwarded them to all the members. Thank you, Chair. But I see there is a document that Honorable Munyai sent on my Gmail account around 10:30 today. But I've just saw that one now, and it's an ANC document. So I haven't forwarded that one, Chair.
It is not ANC document. It's my personal document. Sorry. I've forwarded from my Gmail, but I have my picture of my party.
Yeah, but that is not a committee paper. It's something that you are sharing. All information that we share must be received from the committee secretary. That is my understanding. You know, particularly to members who sit in the committee, Honorable Christians and Honorable Bacha. But I will want us to move forward.
Okay.
Yeah, Honorable Jadu.
Hello, Chair.
Honorable Jadu, yes.
Yeah, Chair, just to verify on I believe that most of the members have received the documents that is clause by clause. And just to verify as to, because mine I receive it from the secretary of the committee. So I believe then all provinces had to send it to the secretariat, and then the secretary, because I'm just taking it from my personal, I receive it from the secretary of the committee. So that was just to verify, Chair.
Yeah, sure. Thank you. All right. Thanks, Honorable Judge. Are you done?
Yes, Chair.
Okay. Thank you very much. Our members, if there's an issue with this, members will know what to do if they have a complaint about the service they receive from our secretariat. I don't want that this committee now, instead of dealing with amendments, we end up dealing with issues with administrative issues, flow of information. We have started dealing with this in my opening remarks. You remember I said that this matter was referred to us on the 23rd of October, and we started dealing with it from the 8th of November last year. So there cannot be anything that is new and surprising to members. And all the time, members had been getting documents all the time. This is the first time that I'm hearing that, from yesterday and then again today, Honorable Bacha. So those matters, you could complain to the, to the chief whip of parliament. We have Mohai here, or the chair of chairs committees. And one of you must be sitting in the whips committee. If not so, then we can also raise it in the whips meeting that your dissatisfaction in relation to the flow of documents. But in as far as I'm concerned, and that I think everybody, you are the only two people who did not get this correct documents for the meeting. But this does not stop you from participating in the meeting, particularly on on the input of the amendments, because we have dealt with this thing. We went through, this is not our first meeting, honorable member. So I'm going to plead that we should continue with this meeting. And if there's anything, you could lodge your complaint and then properly through Parliament committees that deals with such matters. May I ask that we move forward with our meeting? And that nothing stops you, Honorable Baha, from commenting on anything that is said in this meeting, in this sitting, in this amendments. You are free to participate, and you have been participating all the time, you know, from the beginning until today. So let us continue that way. May we move to clause 20. We're done with clause 22.
Thank you, Chairperson. We were on clause 20, and I think it was voted on, and Honorable Nkosi came in to indicate that she got a disconnection, but she was voting to indicate that she is in support as well of that clause. So, Chairperson, it was actually clause 21, and now we move to clause 22, and it was supported by all the provinces, with Honorable Nkosi indicating that she was also just disconnected a bit, but is voting in favor. So we will move from clause 22, Chairperson, and I'll request that voting rights be given to Advocate Breda, and he will just assist me to continue with the process as well. I just need a little bit of some time, but I'm present in the meeting, Chairperson. Thank you so much.
Thank you. Thank you. Let's move to clause 22, and clause 22 seeks to amend section 28 of SASSA, empowering the minister to determine the election of members of a governing body. Over to you, Advocate Van Breda. You may take us through clause 22.
Thank you, Chair. It seems I'm having an issue with sharing my screen. If Advocate Ngema can please share her screen and just to show clause 22 on the screen.
No, Tando, may you make Advocate Van Breda a co-host? It's easier that way.
No, it's fine. Advocate Ngema has shared her screen.
All right.
Chair, we are dealing with clause 22. Was it? We voted on clause 22 already?
No, we voted on 21.
That's correct. Chair, clause 22 of the bill seeks to amend section 28 of the SASSA, and by substituting member of the Executive Council with minister, and provincial gazette with the word gazette, regarding arrangements for the election of members of an SGB of a public school, and by deleting the reference to the words any applicable provincial law. Chair, currently each province deals with the election of members of an SGB in its own preferred way, and this amendment will bring about uniformity across all provinces. Thank you, Chair. That's clause 22.
Thank you very much. That's clause 22, honorable members. I'm waiting for a show of hands, so members want to comment on this. Yeah, amendment of section 28 of the South African School Administration. Any comments from the members? Is it looking at the SGBs and the elections of the. Now, what happens is that in areas of fun that in my village, the schools in my village, 5 of them, one will have an SGB that its term of office ends in January. The other one, it ends in September and all those. And so those are some of the things that this bill seeks to address, so that we know what is the life expectancy of an SGB, the group that is elected this year. Are we going to have elections after 2 years or after a year, every year? So, uniformity, because we are a unitary state in South Africa. We cannot have different laws governing different provinces as if we are a federal republic. Other members, show of hands, comment on this one. Honorable Christians, your hand is up.
Chairperson, apologies. I was kicked out. I'm not sure if it's my network or what. I just want to know which clause are we busy with now, Chairperson?
22.
All right. Chairperson, I just want to make a comment there for discussion and inclusion. And inclusion would be that, look, currently each province deals with the election of members of the SGB. And this amendment is aimed at establishing uniformity across all provinces. So this provision will serve to increase centralization of powers away from the provincial MECs to that of the minister. So I would like to recommend an inclusion as it encroaches on the legislative power of provinces. So it is better regulated by regulations made by the relevant MEC. So the proposal is that the amendment should be deleted. Chairperson, thank you. Completely deleted.
Completely deleted. Thank you, Honorable Christians. Honorable Munyai, Gauteng.
This 22, let me check. I'm saying that with regard to clause 22, is it 22 as you said, my good sir? Yeah.
Yeah, 22, election of SGBs.
Okay. Now look, clause 22, my system just go ups and down. Just hold on, please. Yes, my things went upside down, which is a problem, but I'm attending to it very fast. Clause 22 right now. I'm at clause 22, yes, sir. The issue of uniformity. South Africa, as I said earlier, it's a unitary state, my Honorable Chair. So therefore, it is better provided by the regulation that is being made by relevant MEC. Thus, the proposed amendment should be deleted. Thank you.
Thank you very much. Is there any other input from the members?
Hello, baby.
Plus 22 honorable members of them. Then I'm going to put the vote. That we change, we amend this plus 22 and we leave it as it is. We leave it as it is, or we are amending it. Let's hear from the provinces. KwaZulu-Natal. Eastern Cape.
Sorry, Chair. Sorry, Chair.
Hi.
KwaZulu-Natal.
Yes, KZN.
KZN, we want to emphasize the issue of unitary state. So we in terms of how we want to suggest that the clause 22 should I'm making a mistake here. Okay, let me come back and vote. I just want, I'm trying to, in the process, also read what our committee had said on this issue. I'll come back and vote now, Chair.
All right, thanks. Limpopo. Free State.
No, Chairperson. Hello, Lipompo, sorry, I was unable to unmute myself. Lipompo support the clause without any amendments, Chairperson.
Limpopo support
I'm sorry, Chair.
Without amendment.
I'm sorry to barge in like that, Chair. Is KZN?
Yes, KZN.
My apologies, Chair. We actually support the clause, Chair. Thank you.
Eastern Cape.
Eastern Cape support, Chair.
Limpopo.
Limpopo support, Chairperson, without any amendments.
Free State.
Free State supports, Chair. My apologies. I had issues with my network.
Okay. Northern Cape.
Northern Cape supports.
Western Cape.
The Standing Committee opposes this clause and recommends that it be deleted. Thank you, Chair.
Does not support. Yeah. Northwest.
Northwest supports.
Mpumalanga.
Mpumalanga supports, Honorable Chair.
Gauteng.
Chair, Gauteng is for the deletion of the clause.
Gauteng is for the deletion of the clause. This clause must be deleted. So it doesn't support.
Yes, Chair.
Okay. Gauteng is not supporting. May we get the result, Noltando?
On clause 22, 7 out of 9 provinces are in support, Chair.
7 out of 9.
Yes.
Thank you. Let's move to clause 23.
Thank you, Chair. Clause 23 provides for amendments to Section 29 of the SASSA, which concerns office bearers of governing bodies. And the amendment provides for where reasonably practicable, only a parent member of an SGB who is not employed at the school may serve as the chairperson of the finance committee of that school. And this amendment, of course, seeks to promote good governance. Thank you, Chair.
Thank you very much. This is about the chairperson of finance in the committees, the SGBs. Let's see. Honourable members, that is the clause. Any comments? Because my understanding is that this is about the chairperson of, or Honourable Christians say it was only about the chairperson of the committee, not other committee members. Honourable Christians?
Okay, Chairperson. I see it's just about the finance committee, then that's fine. Thank you, Chairperson.
Pardon, come again?
No, I said no further comment, Chairperson. I thought it was involving an additional committee. So I was going to make a comment on that. So no comment, Chair.
All right, thank you. Any other comment from the members? Input? In the absence of any, I'm going to give the question, how do members vote on this one? It's about the chairperson of the finance committee only, not other committee members. Who agrees with this and who doesn't? Let's hear. Eastern Cape.
Eastern Cape agrees, Chair.
KwaZulu-Natal.
KwaZulu-Natal support the clause, Chair.
Limpopo.
Limpopo support the clause, Chairperson.
Free State.
Free State supports, Chair.
Northern Cape.
Northern Cape supports, Chairperson.
Western Cape. Western Cape.
Chair, I just wanted to check, are we on 23? Are we still on 22?
Yeah. 23, chairperson of
Okay,
finance.
23. The Standing Committee supports this clause with the following amendment. So, with the amendment, believe that is not supporting. The committee proposes that additional amendment is included to provide that a principal may not be a member of a disciplinary committee. That's 23.
Yeah, but this talks to the, yeah, they are voting no.
Yeah, that's 23, yes.
Because they want they wanted to add the chairperson that the principal should not be a member of the disciplinary committee, and this is not about the disciplinary committee. What are the results, Oltando?
Northwest
Who is left out? Northwest. Have all the delegates voted?
Mpumalanga,
Mpumalanga on 23.
Mpumalanga supports Chair.
Pam? Come again?
Mpumalanga supports Chair.
All right. Who else is left out?
Northwest.
Yeah, let's hear Northwest.
Northwest supports.
Gauteng.
Gauteng supports, Chair.
Have all the provinces, have all the delegates voted? Northando, let me check.
Is it 24?
Yes, Chair. All the
24, the
provinces
steering
have
committee.
Oh, no. Njadu, just wait a bit. We are not there. We are still at 23.
23. Oh, I'm done with 23, Chair. Thank you.
Can you give us the
Yes,
results
Chair,
for 23?
Yes, Chair, all the provinces have voted. And on clause 23, 8 out of 9 provinces voted in favor.
Thank you. We move into clause 24. Clause
Thank you, Chief.
24, which seeks to amend section 23 of the SASSA. Advocate Van Breda.
Thank you, Chief. Clause 24 seeks to amend section 32 of the SASSA. And that section, Chair, provides for the status of minors on governing bodies of public schools. So this clause provides for a technical amendment where we are substituting the reference to minor with the word learner, and also adding a subsection, which is subsection 4, which provides that a member of a governing body who is a learner may not take part in meetings at which recommendations for the appointment of staff to the school are decided on, or form part of interview panels relating to the appointment of staff, whether educators or non-educators, or in any other way be involved in the appointment of staff to the school. Chair, that is clause 24.
Yeah, looking at the negotiating mandates of all the provinces, this one seems to be supported by all. Let's hear is there anyone who wants to comment on this one? There's none because there's agreement on this. Let's check with the provinces. Eastern Cape. KwaZulu-Natal.
KZN agrees, Chair.
Limpopo.
Limpopo agrees.
Eastern Cape.
Eastern Cape agrees, Chair.
Free State.
Free State agrees, Chair.
North Delegate Cup.
Northern Cape agrees, Chair.
West Delegate Cup.
Westelijke Kaap support.
Northwest.
Northwest agree.
Mpumalanga.
Mpumalanga agrees, Chair.
Gauteng.
Gauteng agrees, Chair.
Thank you. The results, Noltando.
On clause 24, 9 out of 9 provinces.
All right, now we move into clause 25, which is to amend section 33 of the SASSA. Advocate Van Breda.
Thank you, Chair. Clause 25 of the bill proposes to substitute section 33 of the SASSA, which concerns the closure of public schools. Chair, in this amendment, it provides that the MEC must embark on a comprehensive consultation process before closing a school. And the amendment also empowers the MEC to close a public school his or her sole discretion if there are no learners registered at that school. And further, the MSc must verify by means of a site inspection by an official nominated by him or her that there are no learners registered at that school. Furthermore, it also empowers the MSc to close a public school after following a prescribed consultation process. Chair, the MSc must also inform interested parties of his or her decision and if the decision is to close a public school, he must make arrangements for the learners of the school to attend another school, and where appropriate, make arrangements for the transport of qualifying learners to that school. Thank you, Chair. That is essentially clause 25.
Thank you. Comments from members and engagement? My understanding is that from even yesterday, special schools are not included in the rationalization of schools. So this clause does not, it does not belong here. This amendment, you cannot amend something that is not there. Special schools are not included in rationalization. Honorable Sonjika.
Thank you, Chair. I read the comment by the Council of the Blind, and I think they also misread the clause, because I agree with Chair. Special schools are not, as we speak, are not part of, are not included in the rationalization. So the clause as it stands, there is nothing wrong with it. I think they misread, so we shouldn't even be talking about special schools, because they are not included in the rationalization in any event. So the clause should stand as it is, Chair.
Any other comment from members? In the absence of any, no, there's none. No. I put the vote. Special schools are not included in rationalization of schools. How are we voting on this one? KwaZulu-Natal.
KZN supports the clause, Chair, as it is.
Thank you. Eastern Cape.
Eastern Cape, the clause should remain, Chair. Thank
Limpopo,
you.
thank you. Limpopo.
Limpopo support, Chairperson.
Free State.
Free State is in favor, Chair.
Northern Cape.
Northern Cape supports, Chair.
Western Cape. Thank you.
Western Cape Chair supports with amendment, meaning it is not supporting.
Thank you. Northwest.
Supports. Another supports.
Yeah.
Thank you. Mpumalanga.
Mpumalanga agrees, Honorable Chair.
Gauteng.
Gauteng supports, Chair.
Thank you. Let's move to clause 25. That's 26. Clause 26. Clause 26 seeks to amend section 36 of the SASSA. Advocate Van Breda.
Thank you, Chair. Clause 26 amends section 36 of the SASSA, which provides for the responsibility of government bodies. Chair, what the amendment seeks to provide is that a governing body must seek the approval of the MSc to enter any lease agreements for any purpose, including loans and overdrafts, which already provided for in the section. It also provides that the approval of the MSc is not required in regard to the lease of movable property of the school if the lease is not more than, if the lease does not exceed 12 months. Chair, that is effectively clause 26. Thank you.
Oh yeah, thanks. Was the comments from the members? Honorable Sonjika?
Thanks, Chair. I would want to persuade members on this one. You see where it says the member of the Executive Council, we are proposing that we instead remove the MEC, instead put the head of the department for the administrative and operational purposes. So that's we want to persuade members that we look at removing the member of the executive, instead put the head of the department. But obviously it's what we would want to persuade members to look at. We think it would be more easier to administrate it that way and in the operation sense of the word. Thanks, Chair.
Thank you, Manuel. Any other comment? In the absence of any comment or any hand, anyone want to speak on this, I'll put the vote. How are you voting on this one? That the proposal is accepted for administrative and operational purposes. So,
Yes.
how are we voting? KwaZulu-Natal?
Chair, I'm not sure whether our proposal is accepted. If it's accepted, we vote in favor with that amendment, Chair.
All right. Eastern Cape. Thank you.
Eastern
Limpopo?
Cape agrees.
Oh,
Chair.
thanks. Thank you. Limpopo?
Limpopo support, Chairperson.
Free State?
Free State is in support, Chair.
Thank you. Northern Cape?
Northern Cape supports without any amendments.
Western Cape?
The Standing Committee supports this clause with the
Thank
following
you.
amendment. The committee proposes that member of the Executive Council MEC in clause 26A to be substitute with the head of department. That is the Western Cape, Chair.
Thank you. Northwest?
Northwest support, Chair.
Thank you. Mpumalanga?
Malanga agrees, Chair.
Thank you. Gauteng?
Gauteng
Gauteng,
agrees.
Mabone? Gauteng?
Gauteng agrees.
Oh, thank
Honorable
you.
Chairs.
Thank you, Honorable Chairs. Honorable Munyai. May you give us the results of the vote on this clause? Clause 26.
Sorry, Chair, I just want clarity on this one. The provinces that are voting in favor, are they voting in favor of the clause with the amendment of removing the member of the Executive Council and replacing it with the head of the department or.
Yeah, what was that is
Yes.
that the proposal is accepted for administrative and operational purposes. That it should be the HOD, not the LBC. That is my understanding of what we are voting for.
Oh, all right, sure. So this means 8 out of 9 provinces are voting in favor because the Northern Cape supports with no amendment.
All right. Yeah, give us the results.
It's 8 out of 9 provinces, Chair, that are in support.
Thank you. Thank you. Let's move to clause 27.
Thank you, Chair.
Yeah. And clause 27. Yes, that would be from Brother. No.
Thank you, Chair. Clause 27 provides for an amendment to section 37 of the Act, which concerns funds and the assets of public schools. It provides for a mere technical amendment, Chair. In subsection 1, it's substituting the word directions with the word directives. Thank you, Chair. That is clause 27.
Thank you, clause 27. Yeah. Any comment from members, Honorable Silizi? Munyai?
Honorable Chair, it is supported, no change in this regard.
Thank you. Is there any comment from the members? None.
Supported, Chair.
So then how do we vote? Eastern Cape? KwaZulu-Natal?
Eastern Cape supported, Chair.
KwaZulu-Natal, thank you.
KwaZulu-Natal supports, Chair.
Thank you. Limpopo?
Limpopo supports.
Free State?
Free State support, Chairperson.
Northern Cape, thank you.
Northern Cape supports, Chair.
Thank you. Western Cape?
1 second, Chair.
Northwest?
Chair,
Western
Western Cape on 27. Standing Committee supports this clause as it is a technical correction.
Thank you. Who is that? Northwest? Mpumalanga? Mpumalanga? Gauteng?
Vote in favor.
Mpumalanga
Thank you.
supports, Chair. Mpumalanga.
I support and
Thank you. Is there any province that is left out, Noltando?
Gauteng, Chair. And Northwest.
Northwest? Northwest? Seem to be in the meeting. Northwest? Who else is not there? Which other province is left out? It's only the Northwest.
Gauteng, Chair.
Oh, Gauteng?
oh, I have the full mandate to vote and I'm voting in favor. That
All
there
right, thank you.
will not be changed.
So thank you. Northwest?
Northwest agrees, Chair. Thank you very much.
Yeah, thank you. Can you get the results of the voting on clause 27?
On clause 27, 9 out of 9 provinces are in favor,
you.
Chair.
Clause 28, documents for AGMs.
Thank you, Chair. Clause 28 seeks to amend Section 38 of the SASSA, and that concerns the annual budget of public schools. Chair, the amendment seeks to provide that a document explaining the budget of a school together with the budget itself must be made available to parents before the budget is presented to a general meeting of parents for consideration. It also sets out the procedure that a governing body must follow if it proposes to deviate from the initial budget by 10% or more of the initial approved budget, or if it proposes to reallocate funds for a purpose that is different from the purpose set out in the budget originally approved by a general meeting of parents. Chair, the reasons for the deviation or reallocation must also be made available to the parents prior to the meeting, and parents must be informed that this information will be available for inspection at the school at least 14 days prior to the meeting, and a quorum of 10% of the parents is required for the general meeting referred to. If a quorum cannot be achieved at the first meeting, a second meeting must then be arranged at which no quorum will be required, and a copy of the notice of the second meeting must be distributed to every learner at the school with an instruction to hand such notice to their parents, and that is clause 28. Thank you, Chair.
Thank you. Honorable Munyai.
The clause is supported with no changes.
Thank you. Honorable Ngosi.
Thank you very much, Chair. I was coming to say that the clause is supported without any changes.
Any other hand? You may lower your hand, Honorable Ngosi. Yeah, let's check how we vote on this one. Documents for BG, for AGMs. KwaZulu-Natal.
KwaZulu-Natal supports the clause as it stands, Chair.
Thank you. Eastern Cape.
Eastern Cape agrees, Chair.
Limpopo.
Limpopo agrees, Chairperson.
Free State.
Free State agrees, Chair.
Northern Cape, thank you.
Northern Cape supports, Chair.
Western Cape.
Western Cape support.
Northwest, thank you. Northwest.
Support, Chair. Thank you.
Thank you. Mpumalanga.
Mpumalanga agrees, Honorable Chair.
Gauteng.
We fully support, no changes, thank you.
Thank you. May we give us the results?
On clause 28, 9 out of 9 provinces are in support, Chair.
Thank you. We move into clause 29, amending section 38A of the SASSA. Advocate.
Thank you, Chair. Clause 29 seeks to amend Section 38A of the SASSA, and that provision provides for the prohibition of payment of unauthorized remuneration or giving of financial benefit or benefit in kind to certain employees. Chair, the amendment seeks to extend the provision, application of the provision to a state employee who is paid any additional remuneration or any other financial benefit or benefit in kind. And it requires the governing bodies to provide full details of the nature and extent of the remuneration or benefit. And the reasons for the remuneration, which includes the reasons for the remuneration or benefit, if practicable, the monetary value of the remuneration or benefit, and details of the process that will be followed and resources that will be used to compensate or remunerate the employee. Chair, the amendment is necessary to provide clarity and to reduce the financial burden on parents who pay substantial school fees at public schools. Thank you, Chair. That is clause 29.
Thank you. Are there comments on this one? Honorable Munyai, out there.
Thank you, Honorable Chair. We have not contested or don't contest this clause, and therefore no change.
Thank you. Honorable Nkosi.
Thank you, Honorable. Thank you, Chair. Mpumalanga is not contesting and no change is needed in this clause. Thank you.
Limpopo, thank you.
We support without any changes, Chairperson.
Thank you. The Free State.
Free State support, Chairperson.
Thank you. Northern Cape.
Northern Cape supports, Chair.
Thank you. Western Cape.
On 29, Chairperson, Western Cape support.
Thank you. Northwest.
Northwest supports, Chair. Thank you.
Thank you. Mpumalanga.
Mpumalanga supports, Chair.
Debulela. Gauteng.
Support, no contest, no change.
Thank you. Northern we get the results of voting on
Cape,
clause
Eastern
29.
Cape, Chair.
Eastern Cape, sorry
Eastern
about
Cape,
it.
Chair.
Eastern Cape.
Support.
All right, thank you. Let's get the results, no Tando.
On clause 29, 9 out of 9 provinces are in support, Chair.
Thank you, Notando. We're moving to clause 30, which seeks to amend section 41 of the SASA. Advocate Van Breda.
Yes, Chair, that's clause 30, amending section 41, and that provision concerns the enforcement of the payment of school fees, Chair. And the amendment seeks to insert subsections 2A and 2B, and that's to provide that when a parent applies for exemption from the payment of school fees, such payment may submit additional documentary evidence in the form of an affidavit in instances where information can't be obtained from the other parent of the learner. And also affidavit may provide that they also submit a court order or a copy of a court order or any other evidence that would support the proof contemplated in subsection 2A. That is clause 30, Chair. Thank you.
Thank you very much. Any comment from the members? This one is, I think, looks like there's an agreement from everybody. Let's check how are we voting on this one. Eastern Cape.
Eastern Cape agrees, Chair.
Thank you.
Support, yes.
KwaZulu-Natal. KwaZulu-Natal. Limpopo.
Limpopo support.
Thanks you, sisters. Free State. Free State. Northern Cape.
Northern Cape supports, Chair.
Western Cape.
On 30, Chairperson, Western Cape support.
Free State. Free State. Northwest.
Northwest support, Chair. Thank you.
Northwest. Northwest.
Northwest support, Chair.
Mpumalanga.
Mpumalanga supports, Chair.
Gauteng.
Gauteng support, no change. Thank you.
Thank you very much. Let's move towards the result.
There's still two provinces outstanding, Chair, the Free State and KZN.
Chair.
Free State,
KZN supports. KZN supports, Chair. My apologies.
Thank you. The Free State?
Free State supports, Chair. Free State support, Chair.
Thank you. We're moving to clause 31, which seeks to substitute section 42 of the SASSA. Advocate Van Breda.
Yes, Chair. The clause 31 seeks to substitute section 42 of the SASSA, and section 42 concerns financial records and statements of public schools. And what the amendment seeks to do is to provide that the governing body of a public school must keep detailed records on prescribed aspects of its financial affairs. And under paragraph A, that will include investments and donations. And furthermore, the amendment to paragraph B, which provides that as soon as practicable, but not later than 3 months after the end of each financial year, draw up annual financial statements, which now will reflect all the investments, donations, and funds received and spent by the public school in accordance with the guidelines determined by the MEC. And then it adds paragraphs C and D, which provide, and the governing body must present the financial records and statements to a general meeting of parents and inform the parents that the financial records and statements will be available for inspection at the school at least 14 days prior to the meeting referred to in paragraph C. That is clause 31, Chair.
Thank you. Any comment from members? Straightforward. Honorable Munyai, Gauteng.
It is supported, no changes, sir. Thank you.
Thank you. Honorable Nkosi Mpumalanga.
Thank you very much, Chair. The Mpumalanga is supporting without any changes.
Well, thank you. Any other comment? In the absence of any, let's move to the voting on financial records. Clause 31. Those who support the substitution.
KZN supports supports, Chair.
KZN, thank you. Eastern Cape. Limpopo.
Okay. Eastern Cape, support, Chair.
Eastern Cape support, thank you. Limpopo.
Support also.
Thank you. Free State.
Free State support, Chair.
Northern Cape.
Northern Cape supports, Chair.
Western Cape. Western Cape.
Sorry, Chairperson. On 31, Western Cape support.
Thank you. Northwest.
Northwest support, Chair.
Thank you. Mpumalanga. Gauteng.
Mpumalanga supports.
Thank you. Gauteng.
Gauteng support, my good chairperson.
Fire, thank you. Noltando, can we get the results of the voting on section 32, on clause 32? 31, I meant to say.
On clause 31, 9 of 9 provinces are in support, Chair.
Thank you. So therefore, it is agreed to. We're looking at clause 32, investigations and finances. We seek to amend We're amending section 43. Yeah.
Yes, Chair.
Advocate Van Breda. Sure.
Thank you, Chair. Clause 32 proposes amendments to section 43 of the SASSA. Section 43, which provides for the audit or examination of financial records and statements. Chair, the amendments are proposed to subsections 4 and 5. In subsection 4, the reference to the MEC is now being substituted with the HOD. And furthermore, where the HOD deems it necessary on just cause shown, he or she may A, authorize suitably qualified officers to conduct an investigation into the financial affairs of a public school, and where necessary, after consultation with the governing body, access documents relevant for the purposes of the investigation. The new paragraph B, that will be, and also request the Auditor General to undertake an audit of the records and financial statements of a public school, or C, appoint forensic auditors or forensic investigators to conduct a forensic investigation into the financial affairs of a public school. And then under subsection 5, there's a new paragraph A in that subsection. That is where a governing body must submit to the HOD within 30 days of the end of each quarter a copy of the quarterly report on all income and expenditure in accordance with the directives issued by the HOD. And then the existing subsection 5 then becomes paragraph B. Those are the amendments proposed, Chair. Thank you.
Thank you. Any comment about the proposals from members? None. It looks straightforward. Even on the provincial mandates, there's no comment on this one. There's no contest. Let's vote. Eastern Cape.
Eastern Cape agree, Chair. Support.
Thank you. KwaZulu-Natal.
KwaZulu-Natal supports, Chair.
Thank you. Limpopo.
Limpopo support.
Thank you. Free State.
Free State supports, Chair.
Northern Cape.
Northern Cape supports, Chair.
Western Cape, thank you.
On 32, Chairperson, Western Cape support.
Thank you. Northwest. Mpumalanga.
Mpumalanga supports, Honorable Chair.
Northwest. Gauteng. Gauteng.
Gauteng support, Chair.
Thank you. Can we get the result?
Support, Chair.
Can we get the
Support, Chair.
result, Nolthando?
On clause 32, 9 of 9 provinces are in support, Chair. Thank you.
Thank you. Moving to 33, which seeks to amend section 46 of the SASSA. Advocate Van Breda.
Thank you, Chair. Clause 33 proposes amendments to section 46, which provides for the registration of independent schools. Chair, under subsection 1 of the provision in the Principal Act, which provides no person may establish or maintain an independent school unless it is registered by the HOD. Now, the bill proposes amendments to clause to subsection 4, which now increases the penalty where any person who contravenes subsection 1 is guilty of an offence and liable upon conviction to a fine or to imprisonment for a period, now substituting the period of 3 months with 12 months, so not exceeding 12 months, or to both a fine and such imprisonment. That is clause 33. Thank you, Chair.
Thank you very much. Any comment from the members on this one? Honorable Ngozi?
Thank you very much. Thank you very much, Honorable Chairperson. We support this clause without any change. Thank you.
Thank you very much. We get Honorable Munyai Gauteng.
No contestation and no changes, my good sir.
No changes, no contestations. What's the next province? Who did not vote?
KZN supports, Chair.
KZN. So, Noltando, have all the provinces voted on this? All the members voted on this one?
No, Chair.
There's none. May you give us the results of the vote?
The Eastern Cape, Limpopo, Western Cape, Northwest, Northern Cape, Free State, and Mpumalanga haven't voted as yet.
The chair is tired.
Which one is that, Chair? 32?
I think it's clause 32.
Is it 32 for the Western Cape? The Western Cape support 32?
Clause
Okay,
33,
now,
Chair.
wait a bit.
33.
Let's start from the beginning. That's 33. 33. Eastern Cape, you voted. Oh, I see the hands of Honorable Munyai.
I wanted to correct that is 33, but you corrected it. Sorry, legacy.
Okay. Yeah, 33. Okay, let's start from the beginning. Eastern Cape.
Eastern Cape agrees, Chair.
Yes, KwaZulu-Natal.
KwaZulu-Natal supports, Chair.
Limpopo, thank you.
Limpopo support.
Thank you. Free State.
Free State supports, Chairperson.
Northern Cape.
Northern Cape supports, Chair.
Western Cape, thank you.
33, Chair. Western Cape support.
Thank you. Northwest. Northwest
support, Chair.
Mpumalanga.
Mpumalanga agrees, Chair.
Gauteng.
Gauteng support, Chair.
Members, it will be helpful if people are
Chair,
on their alert. If people are on their alert, you know, because this is what makes me to end up skipping other provinces because I'm going up and down. Who's the iPhone?
Northwest support.
Who is this one with the iPhone? Can you name your gadget? Okay.
Okay. Northwest support.
Thanks. Noltando, may you give us the results of the voting on 30? Pan?
On clause 33, 9 out of 9 provinces are in support, Chair. Thank you.
Thank you. Thank you very much. We move into clause 34, which seeks to amend section 48 of SASSA.
Thank you, Chair.
Advocate Van Breda.
Yes, Chair. Clause 34 proposes amendments to section 48 of the SASSA, and that provision provides for subsidies to registered independent schools. Now, the amendment, the bill proposes amendments to subsection 2, which provides that the MEC may, out of funds appropriated by the provincial legislature for that purpose, grant a subsidy to an independent school. And now the bill proposes the insertion of the words subject to conditions determined by the MEC, and further proposes the addition of the following subsection, which is subsection 6, which provides that an independent school must submit to the HOD within 30 days after the end of each quarter a copy of the quarterly report on all income and expenditure related to the subsidy contemplated in subsection 2 in accordance with directives issued by the HOD, and within 6 months after the end of each financial year, a copy of the audited or examined annual financial statements relating to the subsidy contemplated in subsection 2. That is clause 34. Thank you.
Thank you. Are you done? Or you got kicked out of the meeting?
No, Chair, no, that is clause 34.
All right, thanks a lot. Honorable Munyai.
The conditions are not for the Act. They are to be determined by the Honorable MEC. Thank you.
Any other comment? Thank you. So if I may ask, where will this one fall? Is it under policy or what? Where will this one be addressed? But anyway, that's for the other. So we are there still people want to comment on section 34, subsidy of independent schools?
Maybe
Honorable
Chairperson.
Christian? Yes.
No, Chairperson, on the question that you posed, I was maybe going to ask that perhaps the department could explain the conditions that will be determined by the MEC, whether it will be on a one-on-one basis when the application is made, or as you asked, is there going to be a general determination that guides? And if that will be the case, how will it be determined from the perspective of a regulation or a directive or a condition? Because I think, as the other member pointed out, it is silent on section 48 as such when these grants are done.
All right, thank you. Before I give over to the department, let me give a chance to Honorable Christians.
Yes, thank you, Chairperson.
The
My
mic is yours.
question is also on the conditions, and it is silent on how the subsidy should be spent, the purpose for which the subsidy should be spent, and reporting on the subsidy expenditure, and then also the related types of conditions. So it would be very valuable if the department can explain that to us, as the clause is silent on those. Thank you, Chairperson.
Thank you, Honorable Christians. You may lower your hand. From the department, who will be responding to this?
Good morning, Chairperson and honorable members.
Oh, yeah, DG. Thank you. Which village are you at? Which village are you at?
Chairperson is not DJ, it's me. I'm using two gadgets because we keep getting kicked out. So at least when I'm kicked out from one, then there's another one. But I didn't get Advocate Ngema's statement, but the clause is about subsidies that go to independent schools. And these are given to independent schools on certain conditions that the provincial department puts down. I'll give you an example, because the Constitution says the standard of education offered in independent schools should not be lower than that offered in public schools, determined by government. So there are times when a school is told that if you don't get this pass rate, this pass mark, you may not get a subsidy, you will forfeit a subsidy. So that is determined by provinces from year to year as they set targets every time. I'll give you an example that now no school is supposed to perform under 70 as a benchmark, because nationally we are now at 82 as an example. So any school that will come up with a pass mark of less than 70, then the department, the provincial department, might refuse to release funds. So funds are released on conditions laid down at the beginning by the MEC. Now, what we heard from the Western Cape, it's a request that can we put those conditions now? And the answer is it's not possible, because these conditions change from time to time and they are updated from time to time, and they cannot be in the Act. But if we give a provision to the MEC that when you issue subsidies, you issue them on certain conditions that you will update as you release money, that is sufficient for us. Now, MECs and the departments, by the way, this is there, it's done already, will on an annual basis meet with independent schools and say, here are the conditions that you need to meet in order to get the subsidy. So the clause is trying to emphasize that type of a relationship, that subsidy is not given willy-nilly, it's given on particular conditions, and these conditions are determined at provincial level. And that's what we're voting for, Chairperson. Thank you.
All right, thank you. Will there be comments and or questions and further engagement on this clause? So okay, thank you very much, honourable members. Now I'm going to put the question for the vote. Are we agreeing that the conditions are not for the Act and that they are to be determined by the MEC? Those who agree or not agree will show us when they vote, unless if there's somebody, one of the members who wants to comment before I pass this one. In the absence of any, let's vote. KwaZulu-Natal.
KwaZulu-Natal supports
What we heard is that KwaZulu-Natal supports.
Chair, can you? I think it's a network, but KwaZulu-Natal agrees.
All right, thank you. Eastern Cape.
Eastern Cape,
Sure, thank you. Limpopo.
Limpopo support, Chairperson.
Thank you. Free State.
Free State support, Chairperson. Thanks.
Thank you. Northern Cape.
Northern Cape supports, Chair.
You Western Cape.
Western Cape, I've got an amendment, Chair. Meaning do not support.
Thank you. Northwest.
Northwest support, Chair.
Thank you. Mpumalanga.
Mpumalanga agrees, Honorable Chair.
Excuse me. And Gauteng.
Gauteng supports, Chair.
Thank you. Let's move to. And what's the result, Nultana, of the vote?
On clause 35, 8 out of 9 provinces are in support, Chair. Thank you.
8 out of 9.
Yes, Chair. 8 out of 9 provinces.
Clause 35 seeks to substitute section 51 of the SASSA to provide the clarity in regard to home education. Let's hear Advocate Van Breda.
Thank you, Chair. Clause 35 provides for a complete substitution of Section 51 of the Principal Act. And Chair, essentially what it provides is that it makes it clear that learners may be educated at home only if they are registered for such education. And a parent must at the end of each of the 3 school phases notify the HOD if he or she intends to continue educating the learner at home, and the criteria that the HOD must consider when deciding whether or not to approve an application are also set out. Chair, the amendment further provides that the HOD may, on just cause shown and after notification to the parent, when considering an application, require a delegated official to conduct a pre-registration consultation with the parents and learner to verify the information supplied in the application documentation and to provide support where necessary with the application process. It also sets out the main responsibilities of a parent who wishes to educate the child at home. Chair, the amendment further stipulates that in the case of learners who are not yet registered for home education, application must be made within 30 days after the section comes into operation. Provision is also made for a time limit within which the HOD must respond to an application. And further, the amendment further stipulates that home educated learners must be assessed by a competent assessor at the end of each phase and sets out the options for a home educated learner after reaching the age of 15 or after completing grade 9. Chair, clarity is also provided to ensure that a learner is educated at home after the age of 15 or after completion of grade 9 will not be at a disadvantage. And in the case of a learner who will be writing the NSC, the parent must, before the learner embarks on any studies following grade 9, ensure that the learner complies with the requirements stipulated in Regulation 7 for capital A of the regulations pertaining to the conduct, administration, and management of the National Senior Certificate Examination for a learner receiving home education. Chair, the amendment further provides that the HOD must decline to register a learner for home education if the HOD is satisfied that the parent does not meet certain requirements or that home education is not in the best interests of the learner. And the HOD may cancel a learner's registration for home education if, after investigation, the HOD is satisfied that home education is no longer in the best interests of the learner. And before such cancellation, the HOD must satisfy certain requirements, and provision is also made for an appeal process, Chair. And lastly, Chair, the amendments provide that the Minister may make regulations relating to the registration and administration of home education, and the amendment creates clarity on the powers and responsibilities of officials and of parents of a learner receiving home education, and further proposes steps to protect parents who want to educate their children at home in the further education and training phase. That is clause 35, Chair. Thank you.
Thank you. Honorable members, let's see show of hands those who want to comment on this one. Honorable Christians.
Thank you, Chairperson. I would like to make a recommendation to the committee that this clause be struck or withdrawn in its entirety. And then further to that, I would like to suggest an alternative, that further consultation be done with the homeschooling sector to determine exactly their views on this clause. I believe that not enough consultation was done with them, that homeschooling parents, practitioners, and learners have objected to this clause for a variety of reasons, and that extensive calls for proper consultation and research has to be conducted prior to the approval of this clause. So I think it's very important. I think this is a very important clause, Chairperson, and that we really need to go back to the homeschooling sector to clarify with them, as I believe that more work needs to be done on that. So there are concerns. Concerns have been raised with the amendment. That is amending of section 5116 of SASSA. And this may give the minister almost unlimited power to regulate homeschooling education, Chairperson. So I would therefore like to recommend to the committee an alternative then, that the proposed home education program will maintain standards that are not inferior to standards at comparable public educational institutional. And after this section 51(2)(a)(3), insertion of new subsection 4 and 5 with the proposed new subsections which follow to be numbered accordingly. That is 4. The head of department may not conduct a pre-registration home education site visit contemplated in subsection 3 before informing the parent in writing of his or her intention so to act and the reasons therefore. B, granting the parent a reasonable opportunity to make representations to him or her, which opportunity must include discussions relating to such intention. C, give due consideration to any such representations received. And D, provide the parent with written reasons for his or her decision. And then 5, in conducting a pre-registration home education site visit contemplated in subsection 3, the head of department must ensure that the collection and processing of personal information to verify the information supplied to the application document to provide support where necessary is subjected to the protection of personal information. That is the POPI Act number 4 of 2013. Thank you very much, Chairperson.
Thank you. Let me just hold on a bit. I want to. All right. I was nearly kicked out. Let me check. Yeah, thanks for your input, Honorable Christians. Can you hear what are the other members saying? What's our response? Honorable Sonjika.
Thank you, Honorable Chair. I don't know. I was going to suggest you allow the department to respond because following what the honorable member has just said, she seems to be, okay, she suggested a few things there that we don't agree to the clause, to these changes, and I actually agree with the changes. But she then goes further and raises things that are already raised in the bill itself, where there are consultations and all that. So I thought maybe for the process, to speed the process, maybe the department could respond. I felt like the member is repeating issues that are already set by the bill.
Okay, does anyone from the department wants to comment on this before we engage further?
Thank you very much, Chairperson. Yes, there is no home visit. It's not in the bill anymore. And the recommendations that is given, as the previous speaker has indicated, are all what is covered in the bill. The bill talks to what happens when the HOD has a problem with a registration of a parent. It's clear that the whole bill is about that engagement, that consultation, sometimes even in writing and giving reasons why. And it is there. So the recommendation is covered, Chairperson. Thank you.
Any other comment? Thank you, Ndedendlebe. Or any question to Honorable Christians?
Chairperson, I would just like to gather from the Department of Education whether they believe that they've done enough consultation with the sector and whether or not my recommendation then stands that more consultation should be done, because there was a lot of unhappiness around this particular clause. And there seems to be a few hiccups. And therefore, my recommendation stands that we go back to the sector and liaise with them some more. And I want to just hear the Department of Education's input in that regard.
So what you're suggesting is that we move this thing and shift it to the 6th Parliament, or do you want us from now to go back to public hearings to deal with this?
Chair,
is that your suggestion?
I have a contribution.
All right. Before you even respond, let's see. Let's see, Honorable Munyai, maybe you'll comment after.
Honorable Chair,
yes.
Any suggestion that seeks to say that there was no sufficient consultation with the sector or stakeholders, it should not arise. I can speak here for Gauteng as well. In addition to select committees where public consultation across the country. The key is the following, I must say, that the issues that the honorable members are trying to speak about, as clarified by the department, they are there. So I mean, for me, I will not seek any changes for something that is covered. To suggest that there was not sufficient, remember, honorable men, community can say in their millions, but community don't make the law. The responsibility to make this law, if they fail to convince us as members of the portfolio committee who makes the law, it cannot be regarded as insufficient consultation. There's been sufficient consultation. They spoke in details, various sectors, but I was not convinced with their views. Hence, my view will remain that there's no need to amend this act because it covers everything that honorable member spoke about and as clarified by the department. Thank you.
Thank you. Is there anyone who wants to further engage on this? Honorable Christians, your hand is up.
Chairperson, I want to know if the previous honourable member spoke on behalf of the department, because I specifically asked for a reply from the Department of Education. So I want to know if the previous member spoke on behalf of the Department of Education.
No, the department has responded in the person of James Ndlebe on the platform. And then I asked if there are other members who want to comment further on this. So that's where Honorable Munyai came in. He just gave his input on. Is that okay with you? That he spoke after the department?
I think I asked another question, Chairperson. I asked for a response from the Department of Education whether or not they think more engagement should have been done with the sector. And I would like to hear the response, Chairperson.
Yeah, let me allow this one. Do you want to further respond to this? I'm trying to avoid the
new matter, Chair.
Chair.
There's a request for explanation. There's a request that is sent to the department to respond. Who is that?
It's Sonjika.
Honorable Sonjika, yes.
Oh, no, thanks, Chair. May I beg for indulgence? Maybe you will decide whether the department's response. You see where we are at, Chair, now, as you sit in this meeting, is it's not a department to whether agree whether the consultations were sufficient or not, because consultations we have long passed that process, both from the department's perspective, But where we are at as members of the Honorable National Council of Provinces is to determine whether the bill takes into account all the views. We are not at a stage where we can reverse and say, no, we go back to a public participation process. And I think that the honorable member is misdirecting the question.
Honorable Munyai?
You know, I thought I was not going to speak again on this matter. But it's imperative to really to make my own contribution. With respect to clarity, the bill is no longer with the executive. The executive has done their work, socioeconomic analysis, impact analysis, and as well as the passing the constitutional compliance, and they got the certificate from the state law advisor. Then the bill went to National Assembly, but the bill now, again, is seized with the select committee, not with the department. So to continue to want the department to express a view on the section of the bill, which is the responsibility of the legislatures, it is not going to assist us. I want us to deliberate on the what call and vote on the bill. That's what we need to move forward with. To try to drag the department on the mandate of the legislatures. We can't outsource this responsibility to the department. The department has clarified, members must decide. Thank you.
Thank you very much. I just want to check if there's another hand, anyone who wants to have a bite. Honourable members, this bill has been with Parliament, with us as South Africans, let's say, for the past 7 years. And in that process, there had been public participations that were called in the provinces, and we had even oral submissions in Parliament, and that if, for instance, members feel that there is something that they think needs to be done further, this is not the end of Parliament. This is the 6th Parliament, is not the last Parliament in South Africa. After this election, there will be the 7th Parliament. And this is not the last basic education laws amendment bill. There will be many other amendment bills on basic education as we go on transforming our education, looking for a better life and better education for our children. We'll continue changing the laws in education more than we do our shoes. That will continue. This is not the end. So I was just saying that, and that we cannot stop this process now and say that we are going back to specifically talk to one issue of homeschooling, home education. So we cannot stop this meeting to go back to public participation. It is done. And if there's a feeling that it was not properly done, then we know what to do and where to go. And I'll suggest that we move forward with this unless if there is... Oh, just wait a bit. This one. Okay. Yeah, that if there's to be anything, we should continue with the voting unless if there's one member who wants to talk again on this one. Mr. Ndebe, your name was mentioned that you need to respond to the last question that was asked by the honorable member. The floor is yours.
The questions were direct. As a department, you have consulted sufficiently with the sector. Chairperson, I want to send to the secretary a list and dates of
we cannot hear what you're saying. You are not audible. We can't hear. Mr. Ndebe?
I'm now changing.
Mr. Ndebe, sir.
Sir, I'm now changing the gadget.
Yeah, just start from the beginning because we didn't hear you from this.
Yeah, I'm saying, Chairperson, I would like to send dates of all our consultation meetings with the various stakeholders in this sector, which were held by the Department of Basic Education, to respond to the question whether we have sufficiently consulted. On top of that, I need to indicate that, Chairperson, this clause is about applying what the constitutions require. That is, every school must be registered. And when a school is registered, it means somebody must check whether the school does meet the requirement as stipulated in the Constitution. The most important one is that of an education that is not inferior to the one that is offered by what is determined by the state. And also to protect the interests of the child. We are aware of the different debates that were said there, but the debates are not about registering. It's about the right of the parent to bring children the way they want. They bring in religious issues and all that. So we're saying all these things do not supersede that issue of saying, thou shalt register. That's not negotiable. It does not supersede the fact that at the end of a phase, there needs to be a report that the child is progressing. It's not taking out the fact that the children who are homeschooled need to be protected as well. But this is the basic of that clause. And when you read the clause, the last, very, very last statement, it's a statement that says the minister must regulate on this. So we've been saying all the time that when you see a statement that says regulate, the regulation is always done in consultation with the responsible people that run a particular sector. So if there are issues that are still outside, these are issues that are covered by the last sentence in that clause that says it must be regulated. But may we not negotiate registration? May we not discuss issues of whether people need to report the progress of the children, because that's what the clause is all about, and nothing outside there. And this may not even require these consultations that are being said, we're not doing it. And when people says you did not even research on how this education sector is supposed to be run, and we're saying, but as education, we're not running that education. You're running it yourself as parents. So why do you want us to research? Because all we're asking you is that follow what the Constitution says. Tell us about where the whereabout of your child is. And you tell us that homeschooling, we're fine. And we'll check whether the child is progressing. And we won't come to your home. That's why home visits are not done. But if we're not happy that you're keeping the child and the child is not receiving education, there are the steps in the bill that says how does the HOD intervene in the interest of the child to ensure that the child receives education. And that's it there. The promise is that you will get a long list of the dates that we can confirm that there was proper engagement. Thank you very much, Chair.
Thank you. You've said,
if we don't see your, what if we don't see your?
May you mute? Thank you. Do members want to comment on what was said by Mr. Ndlebe from the department as requested by Honorable Christians? Honorable members, I think Mr. Ndlebe has said more than a mouthful. We're going to move and vote on this clause 35. My understanding is that it is said that there is no changes, and there are those who say there should not be changes, and then there's the input by Honorable Christians that there should be certain changes because, and amongst them, that we should go back to public hearings and all that she mentioned. I've said what I said, and I think we should continue proceed with the voting on this matter. Those who say that no changes should be that it should be and as it is, and those who saying that we need to, there was no enough time for public hearings and the research as of which that Ndlebe pleaded guilty to. That no, it's not our responsibility to do research. It's the responsibility of those who want to homeschool their children to do that. And the understanding being that if you talk about homeschooling, you cannot, all the expenses are on the parent who wants to homeschool. And if you don't have money, then bring your child to a public school. So that's it. I want to check how are the provinces voting on this one, and I'll start with KwaZulu-Natal.
Honorable Chair, KwaZulu-Natal agrees with the PIN as it stands.
Thank you. Eastern Cape.
Eastern Capes agree that no changes.
Thank you. Limpopo.
Limpopo agrees, Chairperson.
Free State.
Free State agrees, Chair.
Northern Cape.
Northern Cape agrees, Chair.
Western Cape.
The Western Cape Chair recommends clause to be removed or to be drawn.
Okay. Northwest. Northwest. We'll pass the Northwest and go to Mpumalanga.
Mpumalanga agrees, Honorable Chairperson.
Thank you. Gauteng.
Gauteng agrees, Chair.
Gauteng agrees. Is there any province that was left out? Okay. And Oltando, we get the results of the voting on clause 35.
On clause 35, with the Northwest outstanding, 7 out of 9 provinces voted in support, Chair.
Thank you. We move into clause 36. Clause 36 seeks to amend section 59 of SASSA. Advocate Van Breda.
Thank you, Chair. Clause 36 proposes amendments to Section 59 of the SASSA, and that provision provides for the duty of schools to provide information. And Chair, the bill proposes amendments to the heading, and the words of schools is being deleted, Chair. Also in subsection 2, there's a minor amendment there where the Department of Education is being substituted with, the National Department of Education is being substituted with the Department of Basic Education. And the bill proposes the addition of subsection 3, which provides that if when applying for admission to a public school or for exemption from the payment of school fees, the parent of a learner or any other person submits or provides information which he or she knows to be false or misleading, submits a document to which he or she knows to be forged, or submits a document that claims that it is a true copy of the original when in fact it is not a true copy, such person is guilty of an offense and liable upon a conviction to a fine or to imprisonment for a period not exceeding 12 months, or to both a fine and such imprisonment. That is clause 36, Chair.
Thank you very much. Any comment from the members on clause 36? Honorable Christians.
Thank you, Chairperson. I would just like to make a inclusion that the MEC should also be empowered to call for information from schools. That's all, Chairperson. Thank you.
Thank you. Any other comment? All right, now I put the vote. Those who vote in favor of the amendment of the clause as it was read to us, and those who do not can now, it depends on how they vote on this one.
Sorry, I raised my hands before the voting. I'm sure you didn't see me.
Oh, Honorable Munyai.
I was saying that it's imperative that bill, that section of the clause remains unchanged and as is. That will be very productive, so that no change is proposed with respect to this clause 36 on penalty for forged documents.
Thank you. Any other comment from the members? Anyone wants to have a bite on? Okay, none. Now I put the vote. Those who are in favor of the changes and those who said no changes, you can now vote. KwaZulu-Natal.
Honorable Chair, KwaZulu-Natal votes in favor of what is proposed currently in the bill. So we do not vote for any changes.
Thank you. Eastern Cape.
Eastern Cape agrees, Chair, with no changes.
Thank you. Limpopo.
Limpopo support, Chairperson.
Thank you. The Free State.
Free State is in favor, Chair.
Thank you. Northern Cape.
Northern Cape supports, Chair.
Western Cape, thank you.
The Western Cape. The Western Cape have amendments, Chair, meaning do not support.
Thank you. Northwest. We pass Northwest. Mpumalanga.
Mpumalanga supports, Honorable Chair.
Gauteng.
Gauteng supports, Chair.
Thank you. May we get the result of the voting on penalties for false documents? That's clause 36. The result.
On clause 36, with the Northwest outstanding, 7 out of 9 provinces are in support, Chair.
Thank you. Let's move to clause 37, which inserts a new section 59A into the SASA. Honorable, let's say Advocate Van Breda. Honorable Advocate. Yeah.
Thank you, Chair. Chair, this is a new provision. It's section 59A, and that provides for dispute resolution. And that stipulates that if a dispute arises between the HOD and a governing body, it provides a procedure which must be followed. And that includes all attempts must be made by the parties to resolve the dispute informally. If the parties are unable to resolve the dispute informally as referred to, then it provides steps which must be taken, including the aggrieved party must give the other party written notice of the dispute, and such notice must include a description of the issues involved in the dispute and a proposed resolution thereof. And in the paragraph C, if the dispute has not been resolved within 14 days after the issuing of the written notice, each party must nominate a representative within 7 days, and those representatives must meet within 14 days after their nomination in order to resolve the dispute. Paragraph D, if the parties cannot resolve the dispute as contemplated, the governing body may appeal to MEC against the decision that gave rise to the dispute. E, if an appeal contemplated in paragraph D has been received, the MEC must within 30 days after receiving such appeal consider and decide on the matter and in writing inform the governing body of the outcome. Then the proposed subsection 2, if a dispute arises between the MEC and a governing body, the following procedure must be followed. All attempts must be made by the parties to resolve the dispute informally. If the parties are unable to resolve the dispute informally as referred to, the following steps must be taken. 1, the aggrieved party must give the other party written notice of the dispute, and such notice must include a description of the issues involved in the dispute and a proposed resolution thereof. Paragraph C, if the dispute has not been resolved within 14 days after the issuing of the written notice contemplated in paragraph B, each party must nominate a representative within 7 days, and those representatives must meet within 14 days after their nomination in order to resolve the dispute. Then the proposed subsection 3 provides that this section does not apply to matters in respect of which the Act makes provision for an appeal process. Chair, that is clause 37.
Thank you. Thank you. Any comment from the members on clause 37? All your mics are active. Some of you, your mics are active, so I don't know whether you want to talk or. Honorable Mateo, your mic is okay. Any comment on this dispute resolution section 37? There seems to be agreement amongst everybody. From my documents here, looking at all the provincial mandates, there doesn't seem to be anything that suggests that there is disagreement on this dispute resolution as contained in clause 37. If there are no comments, I'll put the question. Those who are in agreement with them and those who are not will have to, they will say what they want to say, how they vote. I'll start again with KwaZulu-Natal, favorite province.
Honorable Chair, KwaZulu-Natal is in agreement.
Thank you. Eastern Cape.
Eastern Cape is in agreement, Chair. Thank you.
Thank you, Limpopo.
Limpopo agrees, Chairperson.
Thank you. Free State.
Free State is in agreement, Chair.
Thank you. Northern Cape.
Northern Cape supports, Chair.
Thank you. Western Cape.
Western Cape support, Chair.
Thank you. Northwest. Mpumalanga.
Mpumalanga is in support, Honorable Chair.
Thank you. Gauteng.
Gauteng supports, Chair.
Thank you. We're done with clause 37, voting on dispute resolutions. What are the results?
On clause 37, with the Northwest outstanding, 8 out of 9 provinces voted in support. Thank you, Chair.
Did you say Northwest abstaining?
Outstanding, Chair.
Oh, okay. All right, thank you. Let's move to clause 38, which talks to liability of the state. Over to you, Advocate Van Breda.
Thank you, Chair. Clause 38 of the bill proposes amendments to section 60 of the SASSA, which concerns the liability of the state. That provision, Chair, deals with liability of the state for any delictual or contractual damages caused as a result of any school activity conducted by a public school for which the school would have been liable. Chair, the proposed amendment excludes the liability of the state if the provisions of section 36(2) of the SASSA have not been applied with, Chair, and that is clause 39. Thank you, Chair.
Thank you.
38. Thank you, Chair.
You're welcome. Members, the liability of the state, clause 37, clause 38. What are the comments of the members? Honorable Christians.
Thank you, Chairperson. Chairperson, I would like to make a recommendation to the Select Committee that subclause 1B be substituted with the following subclause. That is B, where a public school has taken out insurance and the school activity is an eventuality covered by the insurance policy. 1, the liability of the state is limited to the extent that the damage or loss has not been compensated in terms of the policy. And 2, if such damage or loss has not been compensated, the state shall be entitled, as against the school, to be indemnified or to the payment of a contribution to the extent that in the amount of which the school is covered for such damage or loss in terms of such policy. Thank you, Chairperson.
Thank you. Comments from members? I just want to check if we say the state should not be liable, but when it comes to Department of Health, when people, there's negligence of doctors and somebody gets hurt in the process, I've seen people suing the state, the Department actually of Health, which means they're actually suing the state for loss of life or limb. Yeah. Let's hear, does anyone wants to comment on this one? Let's hear legal services.
Thank you, Chairperson.
Explain further what are the implications and what does it mean?
Thank you, Chairperson. I just want, in terms of the comments that have been made and clarity that you've just posed, I think as we have indicated previously, this is a principal act we are amending. So what I want to do is just to read out section 62, where it says, where a public school has, section 61B, where a public school has taken out insurance and the school activity is an eventuality covered by the insurance policy, the liability of the state is limited to the extent that the damage or loss has not been compensated in terms of the policy. And then there's an existing act that speaks to state liability to answer the questions that you have raised, as you made an example with the damages done in hospitals or maybe at another department institutions. Subsection 2 of the existing act is already saying the provisions of the State Liability Act apply to any claim under subsection 1. So, like I said, when I was guiding members, we shouldn't read the provisions of the amendment bill in isolation from what the Principal Act already has. Okay. Furthermore, the reference to section 36(2) of the Act, of SASSA Act already, it is also saying, despite subsection 1, where subsection 1 is saying the governing body should take reasonable measures within its measures to supplement the resources, it says, despite subsection 1, a governing body may not enter into any loan or overdraft agreements as to supplement the school fund without the written approval of the MEC. So this will align proper governance and will also ensure that, especially on contractual claims, a mistake would not happen without being picked up within the process, because there is a proper chain that enables the checking and ensuring that proper governance in terms of funds and whatever needs to happen in respect of what would raise a liability against the state is already taken care of and protected before it can occur. So I thought I should just bring that it is not a provision that is done abstractly, but there are other provisions that works in alignment with it so that it is supplemented, Chairperson. Thank you.
It is supplemented by other laws in the country. Thank you. Any other comment from the members? Now I'm putting the vote. Those who say we accept the clause 38 as it is, and those who say they need to make certain changes, I think we can vote on this one. Let's check. Eastern
Chair,
yes.
Chair, I'm okay. I was begging to raise my hand before the voting because I wanted. When listening carefully to what Honorable Christian was saying, I honestly think there is no difficulty in accepting what she was saying. So I just wanted to make that comment before we vote, so that I wanted. I've read it, but if you allow us before we vote, so that she repeats exactly. So, but from what I heard, what she was saying, I honestly had no difficulty to accept and be persuaded with the additions she was making. Or provided, I was going to say, provided that the legal advice might be saying we might be taking a different route altogether with her additions. But I really had no difficulty what she was proposing.
Any other? Thank you, Honorable Sonjika. Any other comment from the members? All right. Now I put the question: those who accept the clause 38 as is. Honorable Christians, your hand is up. Or is it an
Apologies, Chairperson. I think the question that the previous honourable member asked is very important. Can we please get the advice of the legal advisor whether or not my addition would be acceptable in this clause? Please, Chairperson. Thank you. Before we go on to voting.
Does the department want to comment before I give the legal team?
Chairperson, not really, because what legal service was saying is that those issues are there in the Primary Act. And she was saying, don't read this bill separate from the Primary Act. Take the amendments, join them to the Primary Act, they will make one straight comprehensive answer. That the insurance part and those that are not insured are covered. That's what she was saying, Chairperson. Thanks.
Yeah. Thank you, ma'am. The question was
Chairperson,
asked.
thank you so much. I think what I said and what Mr. Ndlebe just reiterated is exactly the answer that I was responding to the questions as to what was suggested, Chairperson. Because from what I heard, unless I heard Honorable Christian incorrectly, and if perhaps for all the members, as the other member asked, if she can repeat, because I came in to try and speak to exactly to what she was suggesting, that it does appear that it is already sufficiently covered, because the provisions must not be read in isolation, but they amplify one another. Perhaps Advocate Van Breda can also come in. Maybe the question or the suggestion by Honorable Christian is maybe not coming through properly. Maybe she can repeat it, but I think the response that I gave is to say the statutes that are already in place and the other provisions of the SASSA Act exactly cover what she was raising. Thank you, Chair.
So it is covered in the Act. Is that what you are saying?
Section 36, Chairperson, read
Section
together
36.
with the section that is being amended, 60.
Okay. Advocate Van Breda?
Yes, Chair, I'm in agreement with Advocate Ngema. The provisions of the Principal Act are indeed sufficient. Chair, what the committee must remember is that what I've read out already exists in the Principal Act. I read out basically subsection 4. The current subsection 4 would now be divided. So the current subsection 4, the wording will become paragraph A. So the wording there, that's highlighted there, that already exists in the Principal Act. What we're doing is adding paragraph B. So I'm in agreement with Advocate Ngema that what the Principal Act provides for is sufficient. Thank you.
Thank you. Ntate Sonjik, your hand is up.
Yes, thanks, Honorable Chair. I think having listened carefully to the board advocates, I think we are ready to accept the clause as it is, Chair, as KZN. So we vote in support of the clause. Thanks.
KwaZulu, thank you. Eastern Cape.
Eastern Cape agrees, Chair, as it is. No changes.
Limpopo.
Limpopo support, Chairperson.
Free State.
Free State supports, Chair.
Northern Cape. Thank you.
Northern Cape supports, Chair.
Western Cape. Thank you.
Western Cape opposed, Chair.
Northwest.
Northwest support, Chair.
Mpumalanga.
Honorable Chair, Mpumalanga is in support.
Thank you. Gauteng.
Gauteng agrees, Chairperson.
Thank you. Noltando will give us the result of the voting on clause 38.
On clause 38, 8 out of 9 provinces are in support, Chair. Thank you.
Thanks. We move into clause 39 on regulations. Clause 39 seeks to amend section 61. Yeah. Advocate van Breda.
Thank you, Chair. Clause 39 amends section 61 of the SASSA, which lists the regulations which may be made by the minister. What the clause seeks to do is to include or to add further regulations which may be made by the minister, and that would be in under paragraph A, capital A. So the minister will be able to make regulations on the management of learner pregnancy. Then to AB on the admission of learners to public schools, and AC on the prohibition of the payment of unauthorized remuneration or the giving of other financial benefits or benefits in kind to certain employees. A capital D on the minimum norms and standards for provincial educator development institutes and district educator development centers. A capital E on the organization, roles, and the responsibilities of education districts. A capital F on a national education information system. And further, it adds subsections 2 and 3. Subsection 2 provides that the regulations contemplated in subsection 1 may provide that any person who contravenes a provision thereof or fails to comply therewith is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 6 months, or to both a fine and such imprisonment. And subsection 3 provides that any regulation made under subsection 1, A capital A, which concerns learner pregnancy, and A capital B, which concerns the admission of learners to public schools, must, before publication thereof in the Gazette, be tabled in Parliament. Chair, that is clause 39.
Thank you. Yeah, this is the clause that this is the clause 39 is the one that where I've actually seen for the first time such great creativity, negative creativity. People being creative negatively, telling lies that the Bella Bill is about pregnancies, children will be allowed to do, that you can go abroad without talking to your parents and what. There have been lots of lies about this one. And I wonder, why do grown-up people tell such lies? Really, it boggles the mind, and particularly if people are so religious, believers, lying publicly. Let me not be judgmental, but and give members a chance to comment on this bill. Just noting the negative creativity that it engineered. Where are we now? Honorable members, let us engage with the input by the lawyer. Honorable Munyai, followed by Date Sonjik. And then Honorable.
Oh, sorry.
Honorable Christians here. Tayo.
Honorable Chair and honorable members and the people of the Republic of South Africa, I'm not going to waste my time with the barrage of propaganda because they are of no value on these issues. So therefore, my response will be no changes to the bill. Thank you.
Honorable Christians.
Thank you, Chairperson. I just want to comment that it is for this exact reason, because there are so many, it's really not clear, it's vague, and therefore there is so many disparities and inconsistencies out there, and people don't understand this clause 100%. So I would like to make a recommendation, because this clause is so vague and because so many people feel uneasy about it, that this clause be struck or withdrawn in its entirety. And additionally to that, Chairperson, it is also too vague, and it gives a blanket regulation power to the minister. And furthermore, the clause cannot be supported as it potentially encroaches upon the powers of provinces, and it is more appropriately determined at provincial level. Thank you, Chairperson.
Thank you. Honorable Sonjika.
No, thanks, Chair. I think where you started, you summarized very well. You see, we have been to a number of public hearings with our legal advisors as well, and people have raised things that are not in the Act. And when you then explain to them, but what you are saying, it's nothing but something that whoever started this thing, some people are really starting to believe it's in the Act or the bill, I mean, and it's not there. And people have, some of the people have understood that they were being lied to. And obviously, we're making a law, an act, but regulations follows that, so that you make the act to be practical, so that it can be implemented. So I think as the bill stands, it's sufficient, and then those who will then follow make regulations will make it practical, so that the act is implementable. So I really want to agree with Gauteng. Let's leave this as it is. Propaganda is what it is, and we'll continue to engage with communities as well, because I don't think it ends with this process. You continuously educate South Africans about the laws we make. Thanks, Chair.
Thank you very much. I want to give before giving advocating them, then let me give the department a chance to say something on this one, because it's a major sin to say that you must take the whole clause out. I don't know if it's because of the learner pregnancy, that little line. I don't know. Let's hear from the department. What is this? Are you really encouraging children as young as 12 years to abort and without telling their parents? There had been accusations of sexual education, that this thing deals with that, I'm told. That is what was said in the public hearings, and people were very, very angry about that. So I just want to hear, what does the department say before giving to the legal department to guide us further on this one.
Thank you, the clause is nothing else except the fact that there are gaps in the department. There are areas that are not covered by our legislation. One of them is management of learner pregnancy. There's a vacuum there. admission of learners in public schools. You only find it in the Act, but there are no regulations. And understand regulations are the step-by-step implementation of what is in the law. Other gaps are prohibition of payment of unauthorized remunerations. There are gaps around minimum norms and standards for provincial education development institutions. There are no regulations around organizations, roles, and responsibility of education districts. There is nothing on National Education Information System, including regulations on home education, except what we indicated that they need to be registered. But these are outstanding. These are pieces of legislation that must be covered. So clause 39, it's nothing else except to request that they be taken care of by means of regulations. Now, it's important that members and also South Africa in large understand the process of regulating, that the regulations are not done by an individual, maybe called a minister, but it means all the stakeholders in each of the topics that I have indicated need to work with the minister to come up with these regulations. So there's no blank check. There's nothing that the minister is going to drive except to say the minister must begin the process, initiate these processes where regulations will be put in place. For example, issues of districts. We don't know how staffing in district is done, and we're requesting through clause 39 that that process begins, and the minister will lead it. And we've been saying throughout this bill that the minister always get her powers from the what you call ministers. It's an instruction to the minister and his MECs that please look into these things that are not there. So the issues of pregnancy and abortion and all those type of things, they are neither here nor there because there are no regulations. We need to start the process of developing regulations. And how do we develop regulations? By working with stakeholders through the very same process that you're dealing with, where there'll also be public consultation and specialists get involved in it. So when we reject the bill, we are actually saying the department must never even begin a process of legislating on this. Thank you, Chairperson.
Thank you. Advocate Ngema.
Thank you, Chairperson. Chairperson, I did indicate that mine is a very easiest of tasks because I just bring the law to the attention of the members. Now, I think what I need to start at as the starting point in dealing with this issue is constitutional law. And if I understand what Section 101 of the Constitution, speaking on executive decisions, is that a regulation is an executive decision, but it is a delegated power that arises out of the main primary owner of the power, which is the legislature. So regulations, if one looks at Section 101 of the Constitution, and I did say that our Constitution is the supreme law of the country, and so whatever we do, so long as it is consistent with the Constitution, it will be found to be legal and constitutional. But whatever we do that is unconstitutional and not compliant with the Constitution, that is where we have an issue and a problem. And then I can give the assurance that if that's what, as the legislature, we do, definitely then such matters would not see daylight when it goes to the courts of the land. Section 101 of the Constitution, under subsection 1 and 3, provides that a decision by the president must be in writing if A, it is taken in terms of legislation, B, or has legal consequences. Now 3, still speaking under executive decisions, it says proclamations, regulations, and other instruments of subordinate legislation must be accessible to the public. What clause 39 of the bill does is to amplify what is already under section 61. And what is under section 61 arise out of subsection 4 of section 101 of the Constitution, which provides that national legislation may specify the manner in which and extent to which instruments mentioned in subsection 3. And in this instance, one of those instruments is a regulation, in which some of the instruments mentioned in section 3 must be tabled in Parliament and approved by Parliament. Now, under existing section 61, the legislature in the previous Parliament that enacted SASSA Act, they said the minister may make regulations, and it lists various numbers of regulations that the minister can make, empowered by section 61. So what clause 39 does is to amplify, as I said, what is already there and what the department has found, that because we have no delegated power to do it, then we are hamstrung. And in light of the provision, just two of the other things that are mentioned that perhaps may have raised the concerns and the propaganda that the chairperson and other members spoke to. The insertion of subsection paragraph AA, it says the minister may make regulations on the management of learner pregnancy. And the department just indicated that because they did not have the enabling power to do that, there is not yet anything in place. Maybe drafts may have been ensued and started, but it was just to ensure that there is a process that is going. But right now, there is nothing that has the official status to say it's possibly speaking to learner pregnancy or whatever. But we know the issue is rife, the issue is happening at schools. But how does then such challenges are managed? Because we all understand this Constitution, it says every child has a right to basic education. Now, the unfortunate part that when a girl child becomes pregnant, it must be kicked out of school because they are pregnant. So these are the issues that needs to be addressed, and they must be addressed with an empowerment that has a legislative power and is a legislative instrument. What the National Assembly did, also after hearing the concerns and all that had happened, because as I said, this has been an ongoing process. It didn't start today. Many phases have taken place. If we look at subsection 2 that is provided under clause 39, that was the suggestion that came from the portfolio committee as well as the bill passed by the National Assembly, which is saying the regulations that are contemplated in subsection 1, not subsection 2, but 3, subsection 3, it says any regulation made under, and in this instance, they said, let us restrict what will come to Parliament, because this was also done to allay the fears of those that are saying, but what if the minister does not consult and does not fully put in place the process that a legislative instrument must follow? So what subsection 3 is basically saying, when a regulation that relates to learner pregnancy or a regulation that relates to the admissions of learners in public schools, once they have put it together, it must come to Parliament. It must be tabled in Parliament, and that will be done before it becomes official, because in terms of the Interpretation Act, once an instrument is gazetted, that means it has officially taken a status to take a public document, and whatever status it would be, whether it's a regulation or a proclamation. So subsection 3 is then saying, before a regulation that is related, for an example, to learner pregnancy becomes a regulation, it will have to be tabled to Parliament. And when it comes to Parliament, then Parliament, again, being the National Assembly and the National Council of Provinces, it will be before them. They will decide how to handle and deal with it and give it whatever, whether they have to approve it or they must engage on it and call on the same process as we were doing with this bill, so that a multi-party democracy is given credence so that members of the public can still make their views. But the provision, the legislation is a framework. It cannot give the details. The details are in the eating of the pudding, and the eating of the pudding will be eaten when the matter is before Parliament. So I believe, Chairperson, what is done here, especially with the addition of subsection 3, it does assist to ensure that a legislative instrument must be consulted, must be brought to the public, and the public must, to a certain degree, influence it by being allowed to engage on it. And that is clearly what clause 39 is attempting to do, Chairperson, I think.
Thank you. Thank you, honourable members. Does anyone want to comment on this one? In the absence of any, I'll put the vote that those who want changes to the clause, and there are those who say no changes are needed. It is all right the way it is. I'll put the vote to do. Right then, how are we voting? KwaZulu-Natal on 39, clause 39 regulations.
KwaZulu-Natal agrees with the clause 39, Chair. Thank you very much.
Good, thank you. Eastern Cape.
Eastern Cape agrees, no changes, Chair.
Limpopo.
Limpopo support, Chairperson.
Free State, thank you.
Free State supports, Chair.
Thank you. Northern Cape.
Northern Cape supports, Chair.
Thank you. Western Cape.
Western Cape opposed, Chair.
Thank you. Northwest.
Northwest supports, Chair.
Mpumalanga.
Mpumalanga supports with no changes, Chair.
Gauteng Maboneng.
Gauteng supports, Chair.
Thank you. We move into what are the results of the vote? Nolthando.
On clause 39, 8 out of 9 provinces voted in support. Thank you.
Okay. We are now at clause 40, the preamble.
Thank you, Chair.
Preamble of the SASA.
Yes.
Advocate Van Breda.
Yes, Chair. Clause 40 proposes a minor amendment to the preamble to the Principal Act. It simply inserts the words, facilitate the education of children through the promotion and protection of the right to basic education. And that is clause 40, Chair.
Yeah. Any comments on clause 40, the preamble? There seem not to be issues here. From my documents here, there's no looking at the provincial mandates, there's no, yeah, everybody seems to be agreeing. Honorable Munyai, your hand is up to 10.
I am covered because they're supporting the bill.
All right, thanks a lot. Anyway, we have to vote. Those who are voting for the changes of the amending of the preamble, KwaZulu-Natal.
KZN supports, Chair.
Thank you. Eastern Cape.
Eastern Cape supports, Chair.
Limpopo.
Limpopo supports, Chairperson.
Thank you. Free State.
Free State support, Chair.
Thank you. Northern Cape.
Northern Cape supports, Chair.
Thank you. Western Cape.
On 40, Chair, the Western Cape support.
Thank you. Northwest.
No.
Northwest? Okay. We'll move from Northwest is
Northwest support, Chair.
okay, thank you. Mpumalanga,
Malanga in support, Chair.
Gauteng,
Gauteng supports, Chair.
thank you. The tandem may give us the results of the voting on clause 40 preamble.
On clause 40, 9 out of 9 provinces are in support, Chair.
Thank you. We now move into clause 41 and 42. Those are amending section 1 and 5 of the EA. Advocate Van Breda?
Yes, Chair. Thank you.
41 and 42. Technical amendments.
That's correct, Chair. So we are now done with the proposed amendments to the SASSA. We are now dealing with amendments to the Employment of Educators Act. Chair, I'll start with clause 41, which proposes technical amendments to section 1 of the Employment of Educators Act. Chair, it proposes the deletion of adult basic education center, and then also in the definition of educator, it's simply deleting the reference to adult basic education center, and then in the definition for provincial department of education, there we are deleting the reference to further education and training institutions as well as basic adult education centers. Chair, that's simply to align the act with the new education dispensation, because those terms are now obsolete. Then in clause 42, we are doing pretty much the same. We are simply removing reference to further education training institutions as well as adult basic education center. So those are minor amendments to clauses 41 and 42, Chair. Thank you.
Thanks. Is there any comment from members on this one? No, and there seem not to be any issues on this one. From my looking at the provincial mandates, it seemed to be all supported by everybody. And then I may just to call for the vote on this one. KwaZulu-Natal, how are we voting on the 4.1 and 4.2 technical amendments?
We KwaZulu-Natal supports, Chair.
Thank you. Eastern Cape.
Eastern Cape support, Chair.
Limpopo, thank you.
Limpopo support.
Alabora, Free State.
Free State support.
Thank you. Northern Cape. Northern Cape. Western Cape.
Western Cape support, Chair.
Northwest.
Apologies.
Northwest. Northwest. Northern Cape.
First support. Northwest supports.
Oh, Northwest supports. Okay. No, thank you. It supports. Mpumalanga,
Malanga is supporting, Chair.
Gauteng,
Gauteng is in support, Chair.
what province is left out? Is there a province that is left out?
No, Chair.
If there's none, may you give us the result of the voting on 41 and 42 technical amendments?
On clause 41, 9 out of 9 provinces are in support, Chair.
Thank you. On members, I suggest that we take a 10 minutes.
Maybe the committee secretary must put both because 41 and 42 were voted together.
Oh, yeah, that's what we said, that clause 41 and 42 technical amendments, they are together. So Wada says that we're all voting for them because they were presented as 41 and 42. Did I understand your concern or your question?
Yes, Chairperson. She only referred to the voted numbers in respect of 41. So I'm just saying for record purposes, it must be both 41 and 42. And then we can take our break.
Oh, yeah,
Hello, Chair.
Noltando, just say that into the system. That is
Oh, all
clause
right.
41.
My apologies. My apologies, Chair. On clauses 41 and 42, 9 out of 9 provinces voted
Thank you.
in support. Thank you.
Thank you. Thank you very much. I suggest that we take a 15 minutes break. And then we'll come back at exactly 20 past.
Thank you, Chair.
Yeah, 20 past 2. Thank you. From
Thank you.
14 to 20 past 2, we'll be in the meeting.
Recording stopped.
Bye, Duncan. Yo, see you on the way. Oh. Yeah, welcome back into the meeting, honorable members. I know it wasn't
Recording in
very,
progress.
and that is not even 20 minutes. I think it was 16 minutes, I think so. We have, yeah. I think we need to go to move on. Remember, we are done with clause 41 and 42. Those were technical amendments dealing with the yeah. Let's look at clause 43. Clause 43 seeks to amend section 7 of the EEA. Yeah, and from my notes, I don't see any. There seem to be agreement on this one, but let's have the advocate Van Breda.
Yes, Chair.
Yeah.
Thank you, Chair. Clause 43 seeks to amend Section 7 of the Employment of Educators Act. Chair, that provision provides for appointments and the filling of posts. Chair, the clause simply seeks to extend the application of the provision to promotions on any educator establishment and to further bring the provision in line with the Citation of Constitutional Laws Act. As you can see there, Chair, the citation that's now been removed, Act number 108 of 1996, that's not consistent with the Citation of Constitutional Laws Act, hence the proposed amendment. That is clause 43. Thank you, Chair.
Thank you. The Employment of Educators Act. Honorable members, that's I'm looking at a show of hands, those who want to comment on. But otherwise, it seemed to be supported by everybody after looking at going through the provincial mandate. There's actually nothing on this one. Can we just check how the members are voting on 43? Or if any member wants to comment before we vote on this one. Let me check if yeah, I don't see any hand on my system. So I would like to check how are we voting KZN on this one. There are no, we all agreed on this one. KZN, just for.
Honorable Chair, KZN agrees.
Thank you. Eastern Cape.
Eastern Cape agrees, Chair.
Thank you. Limpopo.
Limpopo agrees, Chairperson.
Thank you. Free State. Free Stata. Free Stata. Free State. Northern Cape.
Northern Cape supports, Chair.
Okay. Free State. Western Cape.
Western Cape support, Chair.
Thank you. Free State. Northwest.
Northwest support, Chair.
Thank you. Northern Cape. Oh, Northwest. Oh, Northwest support. I mean, Free State. Sorry, Mpumalanga.
Mpumalanga supports, Honorable Chair.
Gauteng Maboneng.
Gauteng supports, Chair.
Thank you. May you give us the result on this one.
On clause 43, with the Free State outstanding, Chair, 8 out of 9 provinces are in support.
Thank you. Honorable members, we now move into clause 44, 45, 46. These are technical amendments. Yeah, I'll give over to part of the technical thing. Over to the Advocate van Breda.
Thank you, Chair. I'll start with clause 44. And proposes amendments to Section 8 of the Employment of Educators Act. That provision provides for the transfer of educators. Here we are simply deleting obsolete terms in subsections 4 and 7, being the deletion of the reference to council and the reference to adult education and training center. In clause 45, which is an amendment to Section 9 of the Act, which concerns the secondment of educators. There in paragraph A, we simply insert in the words or another department. In clause 46, which is an amendment to Section 11 of the Act, which concerns the discharge of educators. There we are also simply deleting references to institutions and centers, and those are clauses 44, 45, and 46, Chair. Thank you.
Thank you. Thank you very much. Members, that's the presentation of clause 44, 45, and 46. Honorable Christians.
Thank you, Chairperson. I'm just speaking on clause 45. I just need some clarity on that clause, Chairperson. If legal can just provide us with some clarity as to why this clause is required in the first place. And having said that, because it is so unclear, it is recommended, I would like to recommend that the clause is struck or withdrawn in its entirety. Thank you, Chairperson.
Thank you, Honorable Christians. May I give this to the department to explain as requested by Honorable Christians? Why do we have this? What's the relevance of this clause 45? Okay, before the department comes in as requested by Honorable Christians, can we have, I see the hand of Honorable Sonji.
Honorable Chair, you see Honorable Chair, my difficulty with what Honorable Christian is doing. She says she wants clarity why the clause is there, but because she doesn't have a clarity, but she still wants it, but she wants the clause to be deleted. So that's my difficulty. What if the clarity makes sense, and that's why I have a difficulty. You want clarity, but you're proposing that deleted clause. I was going to suggest anyway, Chair, that we will want to support 44, 45, 46 as it is.
Thank you. Honorable Christians, your hand is up. Is it?
Chairperson, yes, I'm still requesting clarity on the clause. Thank you very much.
You can lower your hand after that. So,
hello, Chair.
Honorable Njadu.
Yeah. Yes, Chair. I want to agree with Honorable Sonjik. If you want clarity, you cannot have a proposal. So meaning clarity means that you don't understand what is the definition. So I think on that point is that it may be unnecessary delaying the process to have clarity on there's already also a proposal to strike the clause, because I would not strike the clause if I don't understand. Thank you, Chair.
Thank you. Honorable Njadu and all other members, asking for clarity doesn't mean that you don't understand. It also doesn't mean that you don't have any opinion different from what is put on the table. What you're trying to do is, it's like saying, can you say that again? Like, thinking that somebody hasn't applied that or they did not hear you very well. Let's not be judgmental. Let's say the member wants clarity on this issue, and it's her right to ask for clarity. And she can also make her input as a member. So it's neither here nor there. And I don't think we should go into what she said in terms of seeking clarity and having an opinion. Honorable Bacher.
Thank you, Chair. No, Chair, I think that I'm covered with your response. No matter how you ask clarity or for clarity, it doesn't mean that you can't say whatever you want to say. But when the clarity is provided, you can then be able to even say that, then I understand. So I agree with you, Chair, fully. Let's not be technical in our discussion. Let's continue. We're almost done with this meeting. So let's just be kind of fair and tolerant to each other. Thank you, Chair.
Yeah, so now we get it now. And you can still, after getting clarity, and say, yeah, still I don't agree, even with that clarity. Thank you. Honorable Ngozi.
No, thank you very much, Chair. I've got my own understanding on what is said by Honorable Bacher, but I won't go there. Chair, actually, I want to support the clause as presented, clause 44, 45, 46. Thank you.
Okay. Honorable Bacher, your hand is still up.
No, Chair, let me put it down.
With the legacy hand. Department, may you clarify Honorable Christians as per the request? Advocate Breda as we're waiting for the department to respond as per request of the member.
Chair, I'm not speaking on behalf of the department, but Chair, we should look at Section 9 as a whole when refer to the new amendment. Chair, Section 9 simply provides for secondment of educators. And let me just read subsection 1 as well as subsection 2. Any educator in the service of the Department of Basic Education or any provincial Department of Education may, with the consent in writing of that educator, be placed at the disposal of A, another Department of Basic Education, B, another government, C, any council, institution, or body established by or under any law, or D, any other body or person for a particular service or for a stated period on such conditions, in addition to the conditions prescribed by or under any law, as may be determined by the DG or the HOD, as the case may be. In subsection 2, while so placed at such disposal, the educator shall remain subject to the provisions of this Act. Chair, the bill is simply adding to paragraph A, another department. So that means other departments, Chair. Secondments occur in all national departments, and obviously this kind of secondment is subject to the labor relations laws, Chair. And I don't see any concern or issue with the proposed amendment. Thank you, Chair.
You're welcome. Honorable Bacher, your hand is up.
No, Chair, I thought I had dropped it. I'm sorry.
Mr. Ndlebe. May you respond to the request by Honorable Christian?
Yes, am I audible? Chairperson, can you hear me?
Now I do.
Yes, Chairperson. I'm not sure what clarity it's required. I think the advocate has indicated what this clause is all about. It has to do with the movement of staff in terms of the Education Labor Relations Act. And these are things that are done at the LRC section on how teachers need to be treated. And we just ensuring that it is done correctly, Chair. Thanks, Chair.
All right, thanks. Honorable Christian.
Thank you very much, Chairperson. I'm covered.
Thank you. Honorable members, now I move to voting on 44, 45, and 46. There are those who say no changes. There was also an input for changes to which one? Plus 45, no? Yeah. KwaZulu-Natal. How are we voting?
KwaZulu-Natal Chair votes to keep the clauses as they are.
Thank you. Eastern Cape.
Eastern Cape, no changes, Chair.
Thank you. Limpopo.
Limpopo support, Chairperson.
Thank you. Free State. Free state of mind. Northern Cape.
Northern Cape supports, Chair.
Thank you. Western Cape.
Chair, on 44, the Standing Committee supports this clause. On 45, yeah. On 45, the Standing Committee opposes this clause and requests clarity as to why this clause is required in the first place. It is recommended that the clause is struck, withdrawn in its entirety. 46, the Standing Committee supports this clause. Thank you, Chair.
All right. I'm going to separate them, I think so, because on 44, how are we voting? KZN? Mpumalanga.
Mpumalanga is in support, Chair.
Of clause 44. Okay.
Out of clause 44. Thank you.
Yeah. And then KwaZulu-Natal. Limpopo.
Limpopo support, Chairperson.
Free State.
Free State supports, Chair.
Northern Cape.
Northern Cape supports, Chair.
Western Cape. Thank you. Northwest.
Northwest supports, Chair.
Thank you. Mpumalanga.
Mpumalanga is in support, Chair.
Gauteng.
Gauteng agrees with all three clauses, Chair.
Oh, thank you. What are the results on 44? Have everybody voted? Yeah. Noltando. 44?
I was cut out, Chair. 44 Western Cape support.
Yeah. The results on 44?
On clause 44, all 9 provinces voted in support, Chair.
Thank you.
Thank you.
Clause 45, how are we voting? KwaZulu-Natal.
We KZN support, Chair.
Thank you. Eastern Cape.
Eastern Cape support, Chair.
Thank you. Limpopo.
Limpopo support, Chairperson.
Thank you. Free State.
Free State supports, Chair.
Northern Cape, thank you.
Northern Cape supports, Chair.
Western Cape, thank you.
Western Cape require clarity, Chair, and is opposing.
Thank you. Mpumalanga. Oh, Northwest, sorry. Northwest.
Northwest support, Chair.
Okay. Mpumalanga.
Mpumalanga agrees, Chair.
Gauteng.
Gauteng agrees, Chairperson.
Thank you. On 45, give us the results if we have all voted.
On clause 45, 8 out of 9 provinces voted in support, Chair.
Thank you. And 46, how are we voting on 46? KZN? Gauteng?
Gauteng supports, Chair.
Mpumalanga? Mpumalanga?
Mpumalanga agrees, Chair.
Northwest?
Northwest, yeah, dumela, Chairperson.
Rahim. Western Cape?
On which one now, Chair? On 46?
Yeah.
46 Western Cape support, Chair.
Yeah, thank you. Northern Cape?
Did you call Free State, Chair, on this one?
Northern Cape?
Northern Cape supports, Chair.
Free State?
Free State is in support, Chairperson.
Limpopo?
Limpopo support, Chairperson.
KZN?
KZN agrees, Chair.
Thank you. Eastern Cape?
Eastern Cape agrees, Chair.
Thank you. We now move it. Oh,
At the results, Chair, on clause 46, 9 out of 9 provinces are in support.
next?
Thank you.
Who is that?
It's Noluthando, Chair.
Oh, yeah. You said how many? I didn't hear the results.
On clause 46, 9 out of 9 provinces voted in support. Thank you, Chair.
Thanks. She's therefore agreed to. We're moving now to clause 47, list of misconduct.
Thank you, Chief.
Yeah. Advocate.
Yes, Chair. Clause 47 proposes amendments to Section 17 of the Employment of Educators Act. That provision provides for serious misconduct. Chair, there are technical amendments there. They simply deleting the word or in subsection 1 at the end of paragraph E, and also the insertion of a semicolon and the word or at the end of paragraph F, that's subsection 1. And it's also then adding paragraph G, which is another instance where an educator may be dismissed for serious misconduct. And that paragraph reads, committing any other act which in any other law that applies to the educator insofar as his or her employment is concerned is classified as serious misconduct. Chair, that is clause 47. Thank you.
Thank you. Any comments from members on clause 47? List of misconduct. Looking at the provincial mandates here, I don't see anything that shows a disagreement. But then I'll put the question, those who are in favor of all who agrees, who support the clause 47, can I'll call provinces KwaZulu-Natal.
KwaZulu-Natal supports, Chair.
Thank you. Eastern Cape.
Eastern Cape agrees, Chair.
Thank you. Limpopo.
Limpopo agrees, Chairperson.
Free State.
Free State agrees, Chair.
North Delegate Cup.
Northern Cape agrees, Chair.
Thank you. Western Cape.
147, the Western Cape support, Chair.
Northwest. Thank you. Mpumalanga. Gauteng.
Gauteng agrees, Chair.
Thank you. Mpumalanga. Northwest. Mpumalanga.
Mpumalanga agrees, Chair.
Thank you. Northwest. Northwest. All right. We closing the voting now. Nolthando will give us the results of voting on clause 47, list of misconduct.
On clause 47, with the Northwest outstanding, 8 out of 9 provinces voted in support, Chair.
Thank you very much. We're moving to clause 48. It's also technical amendment to section 18 of the Education Employment Act, Educators Employment Act. Advocate Van Breda.
Thank you, Chair. Clause 48 proposes amendments to Section 18 of the Employment of Educators Act. That provision concerns misconduct by educators. The clause simply deletes all references to adult learning centers, which are now obsolete. And that's clause 48. Thank you, Chair.
Thank you. Looking at the negotiating mandates here, you can see there were no issues raised on this one, but do members want to comment before we put the vote? Thank you, none. How are we voting on this one? KwaZulu-Natal?
KwaZulu-Natal supports, Chair.
Thank you very much. Eastern Cape?
Eastern Cape support, Chair.
Limpopo?
Limpopo support.
You can see the Free State?
Free State is in favor, Chairperson.
Northern Cape?
Northern Cape supports, Chair.
Thank you. Western Cape?
On 48, Chairperson, Western Cape support.
Thank you, Baya. Northwest?
Northwest support, Chair.
Mpumalanga? Thank you.
Mpumalanga support, Chair.
Spongekulu, Gauteng?
Gauteng supports, Chairperson.
Rolewang Amanda. We now move, and what's the results for the voting on clause 48, technical amendments?
On clause 48, 9 out of 9 provinces voted in support, Chair. Thank you.
Thank you very much. We're now moving to clause 49, which deals with doing business with the state. Advocate?
Thank you, Chair. Clause 49 proposes the insertion of Section 19, and that provides for conducting business with the state, and that reads from subsection 1. An educator may not conduct business with the state or be a director of a public or private company conducting business with the state. Subsection 2, a contravention of subsection 1. A is an offense, and any person found guilty of such offense is liable on conviction to a fine or to imprisonment for a period not exceeding 5 years, or to both a fine and such imprisonment. And B constitutes serious misconduct, and the employer must terminate the employment of any person who is alleged to have contravened the subsection and who during a disciplinary process is found guilty of such misconduct. That is clause 49G. Thank you.
Thank you. There's insider trading, it deals with that. Are there comments from members? Honorable Christians?
Thank you, Chairperson. I would like the committee to I would like to propose to the committee that the prohibition be confined to state employees, namely departmental posts, as opposed to SGB posts. Also, a proposal that provisions be made for educators who are state employees to submit application to be exempt, subject to necessary and appropriate safeguards. In other words, department must regulate their own people and SGBs must regulate their own people. Thank you, Chairperson.
Thank you, Honorable Christians. Any comments from the members? So you're suggesting that every division must regulate their own people, their members, I meant to say. Honorable Sonjit.
Honorable Chair, no, I disagree with that proposal, and I think the provisions must be left as they are. By the way, all, you see, she's suggesting that there are sections of the state employees who must apply for exemption to do business with the state. And I think that will not be appropriate to all state employees are now prohibited doing business with the state. And so I'm suggesting that we do away with this notion of thinking that people who are employed by SGBs are paid from some miracle money. It's still money that parents work for. So the regulations, it's a state public institutions. The schools are state-owned, public institutions. So I'm suggesting, Chair, we can then be taking a decision on other employees in the same school and suggest other employees are exempted from the same law. So I really, really think this is not even necessary debate. We should be all agreeing that state employees should not do business with the state. And then we will end certain corruption tendencies that are existing all over the country.
Thank you, Dr. Sunjit. Is there any other comment from members on this business insider trading? What? No, insider trading, business with the state, clause 49. In the absence of any, and I put the vote. Prohibition of trade with the state by state employees. With the exception of SGBs. Okay, how are we voting on this one? KwaZulu-Natal.
Chair KwaZulu-Natal support that these provisions must stay like this.
Thank you. Thank you very much. KwaZulu, Eastern Cape.
Eastern Cape supported, Chair.
Thank you. Limpopo. Limpopo. Free State.
Sorry, Limpopo support.
Free State is in favor, Chair.
Limpopo support, Free State is in favor. Thank you.
Yes, dear.
Northern Cape.
Northern Cape supports, Chair.
Thank you. Western Cape.
Chairperson, on 49, the Standing Committee opposes this clause with the following amendments. The committee recommends that the prohibition be confined to state employees, namely departmental posts, as opposed to SGB posts, and that provisions be made for educators who are state employees to submit an application to be exempt, subject to necessary and appropriate safeguard. That is the position of the Standing Committee of the Western Cape. Thank you, Chair.
Thanks a million. Northwest. Oh, yeah, Northwest. Northwest Mpumalanga. Gauteng. Northwest. Mpumalanga. Gauteng.
Gauteng supports, Chair.
Mpumalanga. Northwest, okay. No, I think we are done voting on clause 49, business with the state. No, Tando will give us the results of the voting.
On clause 49, with the Northwest and Mpumalanga outstanding, Chair, 6 out of 9 provinces voted in support.
Chairperson.
So thank you very much. So therefore, it is agreed to. May we
sorry,
move
Chair.
to clause 50, district
Sorry,
norms.
Chair.
Hello? Yeah.
Honorable
I was disturbed by network. The Mpumalanga is voting in favor, Chair.
No, we've already passed that part. They've actually even given the results, so sorry about that. Clause 50, district norms.
Yes, Chair. Thank you. Chair, clause 50 proposes amendments to section 35 of the Employment of Educators Act, which lists the regulations which may be made by the minister. And this clause simply adds another paragraph which saying that the minister may make regulations in respect of norms and standards for district staffing. Thank you.
No, thank you. Any comments from members? Engagement on district norms? Honorable Christians?
Yes, Chairperson, thank you. I would like to make a recommendation to the committee that we oppose this clause, Chairperson. It potentially encroaches on the powers of provinces, and it would be more appropriately determined at a provincial level. So I'd like to recommend that the committee oppose. Thank you, Chairperson.
That's the... So, yeah, thank you, Honorable, for your input. Is there any other input on this one? No, there is none. We're going to move to voting on this clause 50, district norms. How are we voting on this one? There's a feeling that this clause is potentially encroaches on powers of the provinces. That's why there is this objection by Honorable Christians. And others says that no change recommended, that it should remain as it is. So it's now time to vote. KwaZulu-Natal.
Honorable Chair, KwaZulu-Natal votes for clause 50, amending section 35 to stay as it is now. Thanks, Chair.
Thank you. Eastern Cape.
Eastern Cape vote, Chair. No changes recommended.
Okay, thank you. Limpopo.
Hello. Thanks, Chairperson. Limpopo support.
Thank you. Free State.
Free State Chairperson votes in favor with no recommendation enacted or changes rather. Thanks, Chair.
Northern Cape.
Northern Cape supports, Chair.
Thank you. Western Cape.
Western Cape opposed, Chair.
Thank you. Northwest. Northwest. Mpumalanga.
Mpumalanga supports, Chair.
Northwest. Gauteng. Thank you.
Gauteng in support, Chair.
Thank you. Thank you very much. So the voting is closed. Noltando, what are the results on voting on clause 50 district norms?
On clause 50, with the Northwest outstanding, 7 out of 9 provinces voted in support. Thank you, Chair.
7 out of 9. So therefore, clause 15 district norms is therefore agreed to. We move into clause 51, repeal. Advocate.
Thank you, Chair.
Yeah.
Clause 51 proposes the repeal of Section 38 of the Employment of Educators Act, and that's simply because the provision has now become obsolete. Thank you, Chair.
Thank you. Any comment from members? There seems to be agreement from the provincial mandates that I've perused. There seem to be common understanding and agreement on this one. But we have to take it through the vote. Eastern Cape.
Eastern Cape supports, Chair.
KwaZulu Natal.
KZN support, Chair.
Thank you. Limpopo.
Limpopo is in support, Chairperson.
Can see them. Free State.
Free State is in support, Chairperson.
Rolebo Angamanda. Northern Cape.
Northern Cape supports, Chair.
Rolebo. Western Cape.
Western Cape support, Chair.
Badangi. Northwest. Northwest. Mpumalanga.
Mpumalanga supports, Chair.
Bolshoi Spasiba. Oh, thank you very much. Gauteng.
Gauteng is in support, Chairperson.
Thank you. What province did we leave out? None. Okay, thank you. Noltando will give us the result of voting on clause 51, repeal. That repeals section 38.
On clause 51, with the Northwest outstanding, 8 out of 9 provinces are in support. Thank you, Chair.
Thank you. So therefore, it's therefore agreed to. We're moving now to clause 52 and 53. That's also technical. It's also changes to section 18 of Advocate Van Breda.
Thank you, Chair. It's clause 52 that proposes amendment, a technical amendment to Schedule 1 to the Employment of Educators Act simply by deleting the reference to further education and training institution or public adult learning centers. That's referred to in sub-item 2 of item 1. And clause 53 proposes amendments, also technical amendments to Schedule 2 to the Act. And they also deletes the reference to further education and training institutions or public adult learning centers, and that is in sub-item 3 of item 3. And then proposes a minor amendment to item 9, sub-item 5, where that item, Chair, provides that a member of Executive Council or the Minister, as the case may be, will must consider an appeal, simply adding the words that must be done within 30 days after receiving the appeal. Chair, those are clauses 52 and 53. Thank you.
Thank you very much. Any comments from members? I've looking at the provincial mandates. I really don't see anything that suggests that there will be a disagreement on this technical amendment. But we have to take this through the vote again. Let's say KwaZulu-Natal, or are there comments first before I call for votes? There is none. KwaZulu-Natal, how are you voting on this one?
We support, Chair. KwaZulu-Natal.
That's 52 and 53. Okay, thank you.
Yes, Honorable Chair.
All right. Eastern Cape.
Eastern Cape support 52 and 53, Chair.
Thank you very much. Limpopo.
Limpopo support both the two clauses. Thank you, Chairperson.
Thank you. The Free State.
Free State is in support of the two clauses, Chair.
Thank you. Northern Cape.
Northern Cape supports, Chair.
And I thank you. Western Cape.
52, 50. 52 and 53, Chairperson. Western Cape support.
Thank you. When we move to Northwest. Northwest on 52 and 53. Nimanda. Western Cape.
I'm done, Chair. 52, 53. Western Cape support.
Thank you. Northwest. Northwest Mpumalanga.
Mpumalanga is in support of clause 52 and 53, Honorable Chair.
Thank you. Gauteng.
Gauteng supports both clauses, Chairperson.
Thank you. My members, we are at the end of, okay, may we get results for voting on clause 52 and 53, technical, Noltando?
On clauses 52 and 53, with the Northwest outstanding, 8 out of 9 provinces voted in support. Thank you, Chair.
Thank you. So therefore, clause 52 and 53 technical are agreed to. Clause 54. Subtitle.
Yes, Chair. Yes, clause 54 is simply the short title. So that provides that the Act is called the Basic Education Laws Amendment Act of 2022 and comes into operation on the date fixed by the President by proclamation in the Gazette. That's clause 54. Thank you.
Thank you. Thank you very much, Advocate. So, Honourable Member, this seems to be the end of deliberations on clause by clause of the Bella Bill. Let's take a vote on clause 54, short title. Is there any comment? Yes, Advocate.
We may just need to change the year since we're no longer at 22 and we are at 2024. And it's almost the last stage of the bill. But it's also something that can be edited. The year of the that goes with the name of the act, Chairperson. But it can be adopted as is if members so wish.
How do members feel? Are we in agreement?
Chair.
Yeah.
Yeah, I think in terms of the advice that the date to be changed, I think one will to support that. For technicalities.
Thank you. There are no objections to that. I guess if there were any objection, usually members are very vocal people. When they object, they raise their voices sometimes before they raise their hands. So thank you very much, honorable members, for having been. This was very, yeah, it was very involved.
Thank you, Chair.
Pardon? And I'd like to, we have this meeting is still continuing, honorable members. I'm just trying to open a new page.
Hello, Chair.
Honorable Judge, wanted to say something?
I thought, Chair, the last time you were saying you're putting it on vote.
The what? The
54.
No, I didn't do that. Okay. Let's check 54. Let us vote on 54. The short title. Eastern Cape.
Agrees, Chair.
I nearly said in Dongen. KZ. KZN.
Siyavumelana siKwaZulu Natal siyabonga.
Thank you. Honorable Martin.
Limpopo apfumela riyadumela, we agree, Chairperson.
Nda.
Free
State.
Free State ke dumelana le yona, Chairperson, ebile re amohela re lokile.
Thank you. Northern Cape.
Northern Cape agrees, Chair.
Thank you. Northwest. Northwest. Okay. Mpumalanga.
Mpumalanga, Chairperson.
Pardon? Come again?
Mpumalanga is in support, Chairperson.
Oh, Kanimambo. Thank you. Gauteng.
Gauteng is in agreement, Chairperson. Thank you.
Obrigado. Well, thank you. Noel Tandem, give us the result of the voting on the short title definition. Short title.
Western Cape support, Chair.
Oh, thank you. Did I leave anyone out? Any province out? Nothing. May give us the result of voting on. I mustn't forget your name. On clause 54 short titles. The results of the voting.
On clause 54, with the Northwest outstanding, 8 out of 9 provinces are in support. Thank you, Chair.
Thank you. Honorable members, thank you very much. Let me also thank the department and the parliament lawyers, advocates, our lawyers here, and members for putting in a lot to make this to get to where we are. My duty as the chair was to ensure that the bill is processed, and yours as members was to ensure that it is either passed or not passed. So we have done that. This meeting continues. Noltando, we took 2 days in test instead of 1 day for this, so the program is changed. May you flight the new program? They suggested.
Sorry, Chair, my apologies. Before the new program, I see Advocate Van Breda's hand is up.
Oh, let me check. Advocate Van Breda, my screen was okay.
Yes, thank you, Chair. I don't know if the program has changed, but according to the Z list, there is a meeting scheduled for tomorrow to consider the C list. Chair, that will give us too little time to consolidate notes and ensure that the amendments we make or propose are in line with the committee's recommendations and are indeed constitutional and not in conflict with any other laws. And we, of course, need to consult with the department as well. So we would need a little bit more time than 1 day to attend to the C list. Thank you, Chair.
Yeah, that is, I think that is where I should have started. There is not enough time. After this, you need to write and, collate the information and come up with a document that is, that will be credible for us to, to look at. So as a result of that, we actually need some more days for you to be able to do that. It's actually massive work. It's you, the legal, the committee, and the department. Thank you very much. Noltando, there are suggestions of, okay, may you just take us through the suggested program.
Thank you, Chair. Greetings again.
So that we share it with everybody in the meeting and why it has to change. Yeah, to add some days. Sure.
Thank you, Chair. Greetings again, everyone. Chair, the committee was supposed to consider and adopt the C list tomorrow, but taking into account what Advocate Van Breda just said, the program has now been amended. Consideration and adoption of the C list is now scheduled for Wednesday, the 24th April 2024, the day which was supposed to be a day for consideration of final mandates. And the meeting of the final mandates has been moved to Thursday, the 2nd of May, because on Wednesday, the 1st of May, there is a holiday. I think that's just the 2 amendments to the old program, Chair. So consideration and adoption of the C list is now on Wednesday, the 24th of April, and consideration of final mandates and adoption of the bill, of the report of the committee, is now on Thursday, the 2nd of May, 2024. Thank you, Chair. The other committee meetings remain. I hope I've clarified everything.
Yeah.
Thank you, Chair.
So thank you. By implication, it means that I've approved this program and now it is given to members for adoption. So there's not even need to adopt the program. It's our program. Do members want to comment on this? Any comment? Show of hands. And I suggest that we'll deal with the minutes and other matters in the next meeting. Kwangoku, we're all kind. Yeah, we are spent. Thank you very much. If there's no any other thing, I'll declare this meeting adjourned until the day that is it the second or yeah.
Thank you, Chair.
The program. This meeting is adjourned.
Thank you, Chair.
Bye. Hey, Shay, I'm going to pumula.
Honorable Baha.
Yeah, 2 year long.
Recording stopped.
Honorable Baha.
Yes, sir. Utini.
Thank you, Chair.
Sure.
Yeah, the two of you need to be given a prize for tolerance.
No. We are fine. We are fine. We just have minor glitching here and there.
You deserve the Nobel Prize, whatever.
Yeah. No, I will miss you, Comrade Njatu.
Yeah, no, you guys are going to be. You guys will be in Parliament next year. I mean, this after this, I'm gone. Yeah.
Now I think I'm gone, Chair.
Yeah, no.
Hi.
Yeah.
Hi,
This nigga needs rest. Thank you.
Hi, man. It's one of those days.
Long live the chair. Long live the chair.
Oh, yeah.
Recording. I said recording.
The danger do.
He stopped recording.
Okay.
Oh, Chair,
The
well
danger,
done.
I hear you've been opposing here.
This was a marathon, Chair. Thank you so much.
You've been opposing the bill.
But you are still live on TV, on Parliament TV.
Ayo,
What?
hi, bye-bye.
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 The whole day.